Good morning. We want to welcome you out to this year's spring conference. We're excited to have you all here with us. We welcome those that are online watching from home, from their office, from wherever you may be. Just some housekeeping things. The Wi-Fi password are up there. It's the Marriott_conference is the Wi-Fi, and the password is capital M, capital H 2025, no spaces. The materials, we apologize that some of the materials were getting uploaded a little bit late, but everything, presentations as well as handouts that will be discussed are on our webpage at upc.utah.gov, so you can go there and find all of that information. If you have not been here at this Marriott before, the restrooms are just right out the back door out of the hallway. Lunch today is on your own. There are dozens, Utah County people confirm, dozens of eateries within 5 minutes walking distance from here. We're my Utah County contingency. Yeah, so the hotel is going to provide us with a list of places to eat. We'll have that back on the registration table if you want to check that out during the breaks and before we break today. Tomorrow for lunch is when we will present our Prosecutor of the Year Award. So we'd encourage you to stick around for that. We will also, we're pleased to have Derek Brown is the new Utah Attorney General, and his criminal deputy, Stu Young, are going to come down, and we've given them, several minutes just so they can introduce themselves to you, and so you can get to know them. So that is your food. Breakfast. We've got gobs of food, and hopefully David and Chris will not be offended if you get up and walk out and get some more food. We will have breakfast again tomorrow. So if you didn't know that, come hungry tomorrow morning. All sessions are being recorded, excuse me, and we will post them to our webpage. So if you have to leave early, or if you are watching online, and you have to, log off for court or whatever, everything will be posted. You'll need to contact Ron Waite. Hopefully you all know Ron. I'll put up his email address on the last slide to get the access code so that you can watch that, because those are not generally available the first year after the conference. Okay, course evaluation. I know you guys are so tired of hearing me talk about this. We have made it, I don't know how much easier we can do it for you. We've got the QR codes on the table. You can scan the code. It will bring up the course evaluation page. You can even do your evaluation as we go along. So if you don't choose not to use the QR code, you're not here, you go to our webpage. You click on training, you scroll down to 2025, You click on training, it will open, then you go down to evaluations. Excuse me, and you get the drop down to 2025 Spring Conference. 2025 Spring Conference, okay? And here you can save progress, which is what I would encourage you to do. Just pull it up on your phone, have it up on your computer, and as Dave and Chris this morning are going through their presentation, give them an evaluation. As Trent and Tyson are doing their legislative summary this afternoon, do it as you go along so that you are just staying on top of it. Do not hit the save button until you are completely done. If you inadvertently click on that before you're done, you're going to have to contact Ron, and he's going to have to reopen it. You would think that I would run out of stories of people that contact us at the bitter end saying, I didn't do my course evaluation. But yeah, we had people just within the last 6 weeks saying, I didn't do my fall conference or my civil conference or my UMPA evaluation. So please, I don't know how much more I can beg, because it really is an inconvenience to my staff to have to go back in and resubmit a report to the bar. So please get it done. We will close the evaluation page for Spring Conference on Wednesday, May 28th. What day is it going to close? May 28th. That will be the last day that you have to complete your Spring Conference evaluation. After that, Maryland will send in the CLE report to the bar, because the report has to be to the bar the first part of June. So if you rely solely on this conference for your annual CLE, when are you going to complete? What is the drop dead date to complete your course evaluation? May 28th. Okay, have I beat that horse sufficiently? Because I'm going to mention it again. Public service loan forgiveness. I just want to mention this really briefly because you're going to be getting a survey from me. For those of you that have taken advantage of the PSLF, can I just see by show of hands either who is participating or who has reaped the benefit of having your loans forgiven after 10 years? Okay, a lot of you. As we know, executive order came down March 7th, demolishing, is that even a word? Demolishing, doing away with the Department of Education. The PSLF was run by the Department of Education. We don't know what's going to happen to PSLF. NDAA, the National District Attorneys Association, is lobbying strongly that this program continue in whatever form it's going to continue, but that the benefits will continue. And so Department of Education is having a public hearing on April 29th and May 1st. NDAA is going to be at that hearing. They are trying to gather as much information as they can. And so they've asked all of me and my counterparts across the country to send out a survey. And it's going to those of you that are currently participating as well as those of you that have participated, because they want to give data for both. And so when you see that survey in the next couple of days, please respond to that so that we can provide that information to NDAA so that we can continue this really important program. Because we know that many of you choose public service and remain in public service because of the, excuse me, because of the benefit that you get through the PSLF. And so any questions, comments, or concerns, there are our email addresses that you can get a hold of us. Ron is in the back. I'll be in the back. Marilyn is out in the lobby as well as Emma. I should probably put Emma's up there. But we are here around about to help you out. So let me pull up David and Chris's presentation, and I will introduce them. So give me just a second. There we go, right there. Okay, David Simpson. We've heard from David for a couple of years. David does an outstanding job for us. But David is an Assistant Solicitor General. Actually, he is the Division Director of Criminal Appeals. But he's been an Assistant Solicitor General at the Utah Attorney General's office and as I said, is the Division Director. He received his BA from Stanford University and his JD from Stanford Law School. Before coming to Utah, he served as a law clerk to the late Judge Mikhail S. Is it Kenny? I do that every year. You think I'd remember. Kenny of the U.S. Court of Appeals for the Seventh Circuit, and worked as an appellate attorney for the Illinois Attorney General's Office, the Arizona Attorney General's Office, and in private practice. He has taught courses on advocacy, writing, criminal law, criminal procedure for Loyola University, Chicago, Arizona State University, and the University of Utah S.J. Quinney College of Law. So we are pleased to have David with us. Joining him this year, making his first appearance, so please give Chris a warm welcome when he gets up here. Exactly, Chris Ballard. Chris spent 22 years persuading Utah's trial and appellate judges as an Assistant Solicitor General in the Criminal Appeals Division at the Utah Attorney General's Office. He was privileged to serve as Deputy Division Director for 3 of those years. He left the AG's office to practice commercial litigation at Marshall Olson and Hull. And in October 24, he returned to public service as General Counsel and Chief of Staff at the Utah County Attorney's Office. Chris received his undergraduate and law degrees from BYU. So with that, I will turn it over to David and Chris.
Thank you, Bob, for the kind introduction. That introduction was almost as nice as filling out your course evaluations before the deadline, Wednesday, May 28th. Before we get started, by the way, take a look at write down both of these email addresses. So we're going to be doing something in this session that we have done a couple times before, which is sort of running a semi-live Q&A. So if you have questions that come up during the presentation, just email them both to myself and to Chris. We'll keep an eye on our email account, so while I'm presenting, Chris will keep an eye on his email while he's presenting. I'll keep an eye on my email. So if something comes up, send it to us that way. If you have a question, maybe somebody else has a question too, we can all bring it to the group and answer everybody's question together. So again, live Q&A. These are the email addresses. I'll give everybody a quick second to look at that. I'll leave that slide up. But the one thing I always like to say at the start of these presentations as well, just to keep in mind, right? What we're doing is we're going to give you a rundown of what's in the written case opinions of the Utah Court of Appeals, the Utah Supreme Court, and the US Supreme Court. What makes it into those opinions is not necessarily what actually happened at trial. And we know that, right? So it is possible that we may talk about one of your cases, and it's possible that there may be something that the opinion has missed, right? And we recognize that, and as a matter of fact, there are a couple of points during the presentation today where I may point that out, that, hey, I'm not sure that this really accurately reflects what happened based on what I know of the trial record, but at the end of the day, we're bound by the precedent that we're given. So I want to make that clear that if we're discussing something here, that doesn't necessarily mean that, that the appellate court is correct about what it said, but it is the final word just because of the way the system works. The other point is just that the whole purpose of this is about betterment, not blame, right? So we're going to talk about some reversals here. The purpose of talking about reversals is not to shame an attorney who made a mistake, as I alluded to. Sometimes you do make mistakes, sometimes you don't, but the court thinks you did. But this is not about shame. This is about trying to get better. If you look at the way well-run organizations that involved in complex engineering handle things, they're not just looking at what they do well, they're looking at what they do poorly, and they'll look at near misses, right? Here's something where maybe we just dodged a reversal here. Here's something that the court said was improper but didn't lead to a reversal. I want to talk about those too, again, because the ultimate goal is just to try to make us all better going forward. All right, so with that in mind, we'll get started with our first case today, Smith versus Arizona in the US Supreme Court.
Will you tell the court your whereabouts at the time of the carjacking?
I was alone in my Unabomber-style shack. I had nothing to do with that carjacking.
Carjacking? Who said anything about a carjacking? Oh, me.
But didn't you just see?
I'll ask the questions here, carjacker Willie.
Objection!
I'm going to allow it. It characterizes the defendant as a carjacker.
Dad, we've got to tell everyone the truth.
Okay, so let's talk about confrontation and cross-examination. Smith versus Arizona, this is one of the more important cases we saw from the last term of the US Supreme Court. So just as a quick background here of how we got to Smith versus Arizona, because this is a case that in some ways has been like a decade or more in the making. So the Sixth Amendment, of course, provides a defendant with the right to be confronted with the witnesses against him, and this limits the prosecution's ability to introduce statements made by people who don't appear in the courtroom. So the general rule is the prosecution cannot introduce testimonial hearsay unless they produce the declarant and allow the opportunity for cross-examination. So again, you cannot introduce testimonial hearsay unless you produce the declarant and allow an opportunity for cross-examination. The definition of testimonial is really, really slippery in the US Supreme Court precedent, and different justices sort of disagree about what it means. But very broadly, generally speaking, it refers to a statement made for purpose of establishing facts at trial or substituting for trial testimony. So that's kind of abstract. To give you a couple of examples about what that might mean. Statements made during a police interview about a crime are classic testimonial statements. The idea behind giving a police interview about a crime is to provide information about the prosecution of a crime, and you would not want that to substitute for live trial testimony. An example of something the court has held to be non-testimonial is statements made during a 911 call seeking help in an emergency. The rationale being when you're calling 911, the purpose is not to make a record for eventual criminal prosecution, at least in most cases. Your purpose is to get immediate help for what you're looking at right now. So you want to ensure your safety and security. Again, just some more background here. In a case called Melendez-Diaz, the Supreme Court held that forensic science reports are testimonial. So DNA reports, autopsy reports, crime lab reports. So the prosecution cannot just introduce a written lab report and read it into the record. They must produce the scientist who produced the formal report. What happens if that scientist is not available? In another case called Bullcoming, the US Supreme Court said the prosecution can't just have a new scientist come in and just parrot the same conclusions from the report. So, right, it has to have a connection with whoever did the original report. And then in case Williams versus Illinois, this is a case where a new analyst came in because the original analyst wasn't available. They made some of their own new conclusions, and they merely repeated some other conclusions from the prior report, and it like completely broke the Supreme Court. The court produced a whole bunch of fractured opinions. They couldn't reach a majority as to anything, and so it created years of confusion. And so we kind of always knew that eventually the Supreme Court was going to get back to this question again, and they finally did in Smith versus Arizona. So basic facts of this case. So police seized what appeared to be methamphetamine and marijuana from Smith's home. The Arizona Department of Public Safety Crime Lab, so a state-run crime lab, ran tests on these materials at the prosecution's request. Analyst number 1 wrote and signed a sealed official report saying these materials are drugs. And however, analyst number 1 stopped working at the crime lab before trial, and so the crime lab instead sent analyst number 2 to testify at trial. So the analyst number 2 had no prior connection with the case, but they said they were there to give their independent opinion, right? So, oh yes, I wasn't involved in the actual analysis here, but I'm going to give an independent opinion. I'm not just going to read what's in this report. What they did is they read this report, and then they said, yes, now having read all of the stuff in this report, I come to the independent opinion that exactly what the report said. And the Arizona Court of Appeals affirmed. They said, well, look, under Arizona's hearsay rules, you can look at analyst number 1's statements to show the basis for analyst number 2's statements, and that's not a hearsay purpose. So they said because it's not hearsay under Arizona law, those statements are not affected by the Confrontation Clause. So the question as framed by the parties here is, were the first analyst statements in that written report, were those statements hearsay because they were offered for their truth? The parties do not dispute whether the statements were testimonial. And I'll highlight that again. The parties do not dispute whether the statements were testimonial. The only question is whether they are hearsay for purposes of the Confrontation Clause. This is important, kind of plant this in the back of your head because we'll come back around to this at the end. This is going to be an important area of future litigation, testimoniality. Okay, so you have testimonial kind of in the back of your head. Let's bracket that aside. Let's go into whether these statements are hearsay. US Supreme Court reverses this conviction because it finds that the hearsay statements from analyst 1's report that are then repeated by analyst number 2 were offered for the truth of the matter asserted. So they begin by saying, look, the Confrontation Clause is a constitutional rule, right? So if states go around monkeying with hearsay rules, that can't change what the Constitution requires. The definition of hearsay for constitutional Confrontation Clause purpose is fixed at the time of the adoption of the Confrontation Clause in the Sixth Amendment. And then here's their holding. If an expert for the prosecution conveys an out-of-court statement in support of his opinion, and the statement supports the opinion only if it is true, then the statement is offered for the truth of what it asserts. How could it have been otherwise? The whole point of the prosecutors eliciting such a statement is to establish, because of the statement's truth, a basis for the jury to credit the testifying expert's opinion. Right, so put phrase differently, right? The only reason you brought in the statements from analyst number 1's reports was because you wanted the jury to believe that they were true, and that's why they supported the statements of the second analyst. If believed true, that basis evidence will lead the jury to credit the opinion. If believed false, it will do the opposite. But that very fact is why the Confrontation Clause cares about this, right? The defendant has had no opportunity to challenge the veracity of those out-of-court statements in that original report that was doing much of the work. The court kind of adds a couple of caveats here. So they say this doesn't mean you could never have a second analyst testify at all. If the second analyst worked in the same lab, they could testify about things that they had personal knowledge about, right? They could testify about the standards and practices and procedures in the way that the lab runs or the way that it maintains its chain of custody. They could also testify in general terms about forensic techniques or guidelines, lab accreditation. They could also be asked hypothetical questions, such as, assuming these out-of-court statements are true, what would follow from it, right? Assuming the DNA result says this, what would that mean in terms of the probabilities of finding this person's genetic material here? But the state would then, of course, have to separately prove the thing assumed. Because the statements here were admitted for their truth and thus were hearsay, the only remaining question is whether those statements in that first report were testimonial. It's unclear in this case whether Arizona preserved that issue, so the Supreme Court remands it for further proceedings. But in dicta, it suggests, well, if you're trying to figure out whether these statements are testimonial, you should look at whether the second analyst, factors like whether the second analyst testified based on a final formal report or merely preliminary written notes. And then if they were testing them based on notes, for what purpose were those notes created? Was it for the purposes of supporting evidence in a prosecution or for some other purpose? Quick note of the breakdown here of the Supreme Court. So you have 5 justices in the lead opinion, Kagan, Sotomayor, Kavanaugh, Barrett, and Jackson. Justices Thomas and Gorsuch agree with the entire lead opinion except for that little bit of dicta about what might or might not be testimonial. The only dissenters are Alito and Roberts. So this is effectively a 7-2 case. The reason I mention that is basically to say that we're stuck with this rule now, right? This is not something the US Supreme Court is likely to have an appetite for revisiting. So does this mean that everything is falling apart now for cases where you have a scientific analysis, but you don't have the original analyst?
Oh my God, the PTA has disbanded!
No, the PTA has not disbanded.
Yeah, so maybe we don't need to, maybe the sky may not be falling, but we do need to think about this. So this decision does pose huge risks to the state in cases where the state cannot call the original analyst. But those risks can be mitigated with some careful planning, and I'm going to give you some thoughts on how you can deal with these sorts of issues in your cases. And to focus on particularly on 3 questions here. So objection, witness selection, and testimoniality. Objection, witness selection, and testimoniality. So first point, the takeaway from Smith is the confrontation clause problem only arises if a defendant raises a confrontation clause objection. So if there's no objection, you're safe. And this is important because in a lot of cases, defendants will strategically decide they don't want to confront every single analyst along the way. Right? It generally is not favorable for defendants to bring in a whole bunch of forensic scientists to testify about their impressive sounding credentials and training and degrees in support of the state's case. And so in a lot of these sorts of cases, defendants are willing to either stipulate or to not raise a confrontation objection. Just a quick note, though, that the defendant does not actually need to try to call and subpoena the witness themselves. They only need to object. Once they object to the introduction of testimonial hearsay, then it becomes the state's obligation to bring the declarant in. All right, so that's the first point. Look for the presence of an objection. Second point, if an objection is raised, do everything you can to call the original scientist if possible. And that gives us sort of 2 benefits trying to call the original scientist. One is that if you do manage to find the original scientist, that will eliminate the confrontation problem, right? But the other is that if you don't find the original scientist, it's going to help frame the case better on appeal. It's going to give us a better vehicle for taking this up. Right? So if we're going to have to argue to an appellate court that there's some exception that needs to be made or that there's some wrinkle in the law that needs to be ironed out, I would much rather have it be in a case where the state has tried really, really, really hard and just couldn't find the person, or the person has died or fallen off the face of the earth, than in a case where it doesn't look like we tried at all, right? And then the third point, If you have to call a replacement scientist, have the replacement testify from raw data instead of a prior formal report. So for those of you who do like DNA cases, if you've ever seen those sort of raw quantifier reports that the machines spit out, have your new analyst testify from that raw machine-generated data instead of from the prior formal report. And the reason for this is that it's earlier in the chain, and the earlier in the chain it is, the less formal it looks, and the less likely it is to be testimonial. Remember when I said keep the sort of testimonial point in the back of your head? So it's easy to say, well, look, this is a signed, stamped, sealed report written by a human being for submission in court. That sounds a lot like a testimonial statement, a formal statement admitted to substitute for testimony. But if it's just a spit out computer reading from a computer, the computer has no intent at all, much less the intent to make a formal statement. So that is less likely to be testimonial. This is in discussions that I've seen with the US Solicitor General's office. They think that this is going to be sort of the next big area to look at is, and sort of the best way to cabin the practical limits of Smith is going to be to analyze data further along the chain, earlier along in the chain, I should say, so that it's less likely to be testimonial. This is not going to work in every case. In autopsies, if you don't have the original medical examiner and this is not recorded in some way, you may have some really, really difficult questions about how to deal with autopsies. Stay tuned for that. I think that's also going to be another area of case law that we're likely to see advances in shortly. All right, so that's Smith versus Arizona and confrontation.
Thanks, David. Okay, another case from the US Supreme Court that came out very recently. This is a case, it's not about drawing a line, it's about blowing right by a line. And hopefully, this is a cautionary tale for prosecutors to not cross the line that the prosecutors crossed in this case, Andrew versus White. Okay, so the background is that the wife, Brenda Andrew, the defendant, she plots with her lover to kill her estranged husband. And there is overwhelming evidence of guilt here, and I wanted to stress this because there's no reason that this conviction should have been reversed, but for the prosecutors just blowing way past the limits on the evidence that they introduced, on prejudicial evidence. So here's what happened. There's overwhelming evidence of guilt. So this couple is separated. The husband usually comes and picks up the children. He just waits at the curb. This is their normal routine. He waits at the curb and she brings the kids out. It's Thanksgiving. Husband's there to pick up the kids. But instead, the wife says, honey, can you come into the, well, probably not honey, right? But can you come into the garage? I need you to light the pilot light on the water heater. So he goes into the garage when two masked men burst into the garage and kill him, shoot him dead with a 16-gauge shotgun. In her house, there are 16-gauge shotgun shells from the same manufacturer, imagine that, as the expended shells. She has a superficial gunshot wound on her arm, but we come to find out that that gunshot wound isn't caused by shotgun pellets like she claimed. It's caused by a .22 that was fired at close range. Her co-defendant had purchased a .22 handgun just a week before the murder, about a week before the murder. And she met her co-defendant while teaching Sunday school, while the two taught Sunday school together. So that's why Brenda Andrew is the Sunday school killer. You can buy this book on Amazon if you want to and read all about it. So she meets him teaching Sunday school and they begin an affair. Now, her co-defendant was an insurance salesman and had sold the husband an $800,000 life insurance policy a while before this happened. Now, Ned Ryerson is not the co-defendant. This is the co-defendant. And it's weird that they handcuff them together. I think that is weird too. So the wife didn't even go to her husband's funeral. Instead, she went to Mexico with the co-defendant and her children. She had no intent to return. The only reason she came back to the United States is that they ran out of money. And there was a lot more evidence supporting her guilt. In my opinion, there's overwhelming evidence of guilt here that should have meant that any error would be harmless. But that's not the case, and that's why we're talking about this case. So she gets convicted of capital murder. She's sentenced to death. But there was a ton of 404B evidence that some of it's 404B, some of it is, I don't know what you'd classify it as, but there was a ton of evidence that the prosecution introduced that they shouldn't have. They put on evidence of the wife's extramarital affairs that went back 2 decades. They put on testimony from one man with whom the wife had an affair to testify that not only had he had an affair with her, but she had come on to his 2 adult sons. The prosecution called 2 witnesses just to testify exclusively about how she dressed provocatively. That was the extent of their testimony. This was another interesting piece of evidence. She changed her hair color to red the day after hearing her husband's best friend say that he preferred redheads. So this is all evidence that the jury is hearing in support of the prosecution's case, and hearing it all without any kind of limiting instruction. It all just comes in. And then here in closing argument, the prosecution uses the wife's thong underwear as a prop in their closing argument. They went really far. And we have the Oklahoma prosecutors to thank for this. So on appeal, the state had to concede that much of this evidence was irrelevant, but argued that it was harmless. And they were successful in state court. The Oklahoma Court of Criminal Appeals agreed, but there was a strong dissent that said the prosecution engaged in an egregious pattern of introducing evidence that has no purpose other than to hammer home that Brenda Andrew is a bad wife, a bad mother, and a bad woman. So they're able to preserve the conviction in state court, but then the defendant files a federal habeas petition and raises a due process challenge to the 404B evidence. So not just this shouldn't have been admitted under our state rules, but in fact, there's a constitutional protection against this kind of evidence. And the 10th Circuit disagreed. They said, yeah, in Payne versus Tennessee, there was this broad legal principle that the Supreme Court mentioned in one sentence that said that improperly admitted evidence might be so unduly prejudicial that it renders a trial fundamentally unfair under the Due Process Clause. But that was not clearly established federal law under Payne. So I know that none of you guys, well, probably most of you don't do federal habeas law, but the standard is you have to show that the state court decision was contrary to clearly established federal law. That's the standard that the 10th Circuit was dealing with. And they said this aside in Payne versus Tennessee about unduly prejudicial evidence making a trial fundamentally unfair under the Due Process Clause, that wasn't clearly established at the time. So goes up to the U.S. Supreme Court, and we get a per curiam decision from the Supreme Court saying that Payne made it clear that when evidence is introduced that is so unduly prejudicial that it renders the trial fundamentally unfair, then the Due Process Clause provides an avenue of relief. And they rely on Judge Bacharach's dissent from the 10th Circuit, where he characterized the evidence as, from start to finish, the focus was on Ms. Andrews' sex life. It portrayed her as a scarlet woman, a modern Jezebel, sparking distrust based on her loose morals, plucking away any realistic chance that the jury would seriously consider her version of events. This was fundamentally unfair. So this is the holding from the U.S. Supreme Court. We do have a dissent from Thomas and Gorsuch, and they take the majority to task for elevating this one sentence from Payne versus Tennessee to clearly established federal law. They characterize the majority's opinion as taking the broadest possible interpretation of that one sentence, and they point out that in Estelle versus McGuire, the United States Supreme Court left open the question that they now in Andrew say that Payne had resolved. So this is more from the dissent. The dissent redefines clearly established law to include debatable interpretations of our precedent. And then they say we would have found this evidence inadmissible or harmless. The admission of this evidence harmless because there was overwhelming evidence of guilt. And some of this evidence was, they could think of reasons why this evidence was relevant. But the point is that pushing the envelope and crossing the line really risks creating bad law, and that's what we have in this. That's what this situation has produced. Because now, not only do prosecutors across the country have to argue that this evidence is admissible under the rules of evidence, defendants now have a constitutional protection against the admission of allegedly improper or irrelevant evidence or prejudicial evidence. So we now have one more argument that we have to address, and it's enlarged the contours of what constitutes clearly established law. I think the dissent makes a great point about Payne versus Tennessee, but because of what the prosecutors did in that case, the Supreme Court was so annoyed by it that they were willing to go to great lengths to allow relief there. So be aware that there is a due process line for the admissibility of evidence, and stay very well on the correct and fair side of it. Make sure that when you're introducing 404B evidence or any evidence that could be potentially inflammatory under Rule 403, that you've got a clear reason for its admissibility, and you can articulate that and explain why that's not improper evidence. Okay, so that's Andrew.
So a couple of the questions that we received, can we now expect a due process challenge for every Rule 404B error?
Maybe, we can.
I think one could be raised for every 404B error now,
right.
Yes.
Yeah, which is the problem with prosecutors going way too far with that evidence.
And then
another one?
Yeah, well, one that I will I'll share with you afterwards that I think is more directed towards you.
Oh, good.
You know who you are. But there was also an FYI from Tyson who was pointing out, and this doesn't surprise me having talked to Arizona, that Arizona dismissed the case against Smith in Arizona versus Smith on remand. So we're not going to get the testimoniality question answered in that case. I think that's just as well. I think the statement probably was testimonial in Smith, and so they're not going to get an answer that they want. Tyson had said, I've been working with this a lot in the toxicology lab, and this has been an area where this happens regularly. Fingers crossed they can do what they need, what needs to be done to preserve these cases anytime one of their toxicologists leaves. So thank you, everybody. Okay, next one, unanimity cases. If you've been coming to these for a couple of years, you'll have noticed I have a section on unanimity cases in pretty much every presentation I've given every year. And that's for good reason. This is, I think, probably still the #1 reason for needless reversals of criminal cases. And due to the specific nature of how these unanimity cases work, Where we see the reversals most frequently are in serious sex cases involving multiple offenses. So if I'm sounding like a broken record, it's because this is really, really important. This is the number one way in which you are likely to see an otherwise sound conviction get reversed by our appellate courts. So I'm going to go, as I do sort of every year, do a quick overview of unanimity. What's the problem of unanimity that we're talking about here? Then we'll talk about what the recent cases, in this case, the cases from the last couple of years have held, and then we'll talk about what we can do to keep your case from being the next reversal. So, first point, what is the problem of unanimity? So this dates back to a case from the Utah Court of Appeals called State versus Aliris back in 2019. So Aliris is charged with 6 counts of aggravated sexual abuse of a child, 2 against his daughter and 4 against his daughter's friend. So 6 different counts, 4 against one victim, 2 against another. During closing argument, the prosecutor described a whole bunch of different acts of prohibited sexual touching and said the jury could convict on whichever ones that it wanted to. The jury did this. They got really, really confused by this and sent a jury note saying, hey, we're confused. How do we, like the prosecutor just listed a whole bunch of different stuff that they said they could convict on. How does that match up to all the different counts that we have here? And the court did what courts so often do and says, just refer to your instructions. And so the jury ends up convicting on only 2 counts out of the 6, 1 for each victim, and acquits on everything else. On appeal, he argues his counsel's ineffective for not ensuring that you're tying specific acts to specific charges. And the Court of Appeals agrees and reverses, holding it's objectively unreasonable for trial counsel to propose instructions that did not require the jury to be unanimous as to the specific acts supporting each count of conviction. The jury should have been instructed to agree on a specific criminal act for each charge in order to convict. Otherwise, they could have completely disagreed on which acts in fact occurred and which acts were illegal. So what does this mean? So if you're trying to figure out what the difference is between what a jury does and does not need to be unanimous about, take a look at the Supreme Court's opinion in State versus Hummel, and they draw a distinction between unanimity of theories and unanimity of elements. That sounds kind of abstract, so to make it a little bit more concrete, the basic idea, I think, is this. If what the defendant did could be charged as more than one crime, you have a potential unanimity problem. If what the defendant did can only be charged as one crime, you don't. So to take the example from Hummel, imagine if you have a disagreement in the record about whether the defendant entered a house to commit, I say robbery, it really should be burglary, I apologize, but there's a front door smashed out, the back door smashed out. So we don't know whether the breaking and entering occurred through the front door or the back door. Does that create a unanimity problem? The answer would be no, because either way, it's only one burglary, right? We don't know which way they came in, but either way, it's only one. Where you would need to be unanimous is, say you have a robbery in Salt Lake City on Wednesday and one in Provo on Friday, right? Those are 2 separate criminal acts. You could charge each of those criminal acts separately, so the jury needs to be unanimous about them. So again, the problem arises where a charge or charges encompass multiple criminal acts, any of which would be separately enough to sustain a criminal conviction. So to make this sort of more concrete in the context of sexual abuse, where this comes up so frequently, imagine you have a trial where there's evidence of a touching of the victim's buttocks on Monday, touching of the victim's breasts on Tuesday, touching of their pubic area on Wednesday, right? And then at trial, that's only charged as 1 count of sexual abuse of a minor. The concern is that you could have jurors, they all agree he did something wrong, but they're not sure what, right? So maybe 4 of them say we believe beyond a reasonable doubt that he touched the buttocks, 2 say he touched the breasts, and 2 say he touched the pubic area, but no one, the jury's never unanimously agreed on which of these independently chargeable criminal acts has actually occurred. I saw a hand up over here. Yes. Yeah, so the question here was on a recent case, defense argued that the jury did not just need to be unanimous about which particular act of physical touching occurred, but also what type of criminal intent the defendant had when engaging in each act of touching. And your suggestion was that's wrong, and I think that is wrong. That you don't need to be unanimous about the intent for the reasons I discussed before, right? If I engage in, one act of illicit touching of the microphone, you can only charge this once, right? No matter what's going on in my head, no matter if you have different theories about what's going on in my head. We'll get to another case a little further on, State versus Sissel, that may give you some ammunition to use in cases like that as well. And Hummel also talks about it. Okay, so this is the problem of unanimity. This is what we're worried about, is multiple potentially independently chargeable acts, and the jury might not be unanimous about which one the defendant actually committed. So, what have the recent cases this year on unanimity held? So we went into 2024. We've gotten a bunch of bad law from the Utah Court of Appeals over the last couple of years about unanimity. And so we went into 2024 with two cases about unanimity before the Utah Supreme Court, Chadwick and Baugh. And our hope was that this would help us be able to unwind some of this really unfavorable law about unanimity. So let's see whether our hopes have been, oh no. Okay, well, so State versus Chadwick. Like I said, these come up so frequently in sex cases. So this is a case where the defendant is charged with 4 identical counts of sexual abuse of a child. So an information where you basically just have the text of the statute defining sexual abuse of the child listed 4 times as 4 separate charges. It doesn't distinguish between what those acts actually involved or when they occurred. To their credit, defense counsel argued that the jury had to agree as to which specific act supported each count. And to their credit, the prosecutor agreed with defense counsel. The prosecutor agreed, yeah, you should tie these all to each individual act, to each individual charge to a specific act, and you need to be unanimous about it. Maddeningly, the district judge messed it up. The district judge, having heard the advocates correctly argue this point, went back in and undermined those correct statements of the law. Counsel may have suggested specific behaviors correspond to specific counts during closing argument, but arguments and characterization of the evidence by counsel are neither pleadings nor facts. It's for you to determine from consideration of all of the facts whether the state has proven this beyond a reasonable doubt, once, twice, 3 times, or 4 times. And you may choose to relate specific conduct or incident to a specific count to assist in your deliberation, but that's up to you. So essentially, the district court tells the jury, you don't need to match a specific act with a specific charge, or at least that's the way the appellate courts interpret it. So the Utah Supreme Court in Chadwick says this is a preserved and reversible error. Constitutional error occurs when the circumstances of the case undermine our confidence in the unanimity of the verdict. And because a non-unanimous verdict has long been viewed as an invalid one, we require a certain degree of confidence that the verdict is unanimous, otherwise it's constitutionally infirm. The court doesn't describe every case that's going to undermine its confidence in the verdict in this way, but at a minimum, it includes the sorts of cases that I've been talking about here. Multiple act cases in which the counts charged are identical and the counts are not linked to specific conduct, each tied to each specific count. And these cases merely instructing the jury that they must be unanimous as the defendant's guilt leaves room for confusion. The worry is the jury may say, well, we don't all agree on what particular acts of touching occurred at what time, but we all agree he did something wrong, so we'll just convict him anyway. That's the worry. Most of these cases arrive in ineffective assistance of counsel, and for good reason, because it's actually often not in the defense attorney's interest to object to these sorts of errors, because it's a good chance of an automatic reversal on appeal. But this is a rare case where it's preserved. And so this leads to the second holding here. Where the error is preserved, the court will reverse unless the state can show the error was harmless beyond a reasonable doubt. So we have to meet like a constitutional, beyond a reasonable doubt, harmless error standard. Side note here, this is actually the first time that this standard has been applied to Utah constitutional errors. So we came into this hoping we could get the Utah Supreme Court to unwind some of this unfavorable case law, and what they actually did is double down on it and gave us a really stringent harmless error standard to meet as well. The second of the Utah Supreme Court cases, State versus Baugh. Again, a child sexual abuse case. Baugh is charged with 2 counts of aggravated sexual abuse of a child, but at the trial, the victim testifies about 3 separate acts of abuse. The prosecutor told the jury that it could rely on any of the 2 acts to convict. Kind of query whether they actually did that if you look at the record in Baugh, but that's the way the court interprets it. The Court of Appeals held that this was ineffective assistance for not requesting a specific unanimity instruction. The Supreme Court agrees and reverses this conviction as well. So, what's the takeaway from Chadwick and Baugh? The takeaway is that for now, Alerus and its progeny are here to stay, right? Every prosecutor in Utah needs to be aware of unanimity principles. Every prosecutor in Utah needs to be aware of these principles. And if you aren't, you cannot count on the district court or the defense's lack of objection to save you. You cannot count on the lack of an objection to save you because our courts are very, very willing to reverse for ineffective assistance of counsel, even when there's no objection. From our view on the appellate side, we have continuing strategies we think we are going to try to use to push up against this, but this is now a project of a decade. This is going to take years and years and years to unwind this if we are able to at all. So in the short term, every prosecutor in Utah needs to know what this is about.
But,
okay, yeah.
I mean, arguably it's plain error now, right?
Yes.
Given Chadwick and Baugh.
Yes, arguably it's plain error now. And yeah, there are some technical ways in which we can push against it, right? One of the issues, as I pointed out, if you think back to like Alerus itself, right? You had 6 different charges. The jury wasn't told how to deal with them, and the jury got confused and only convicted on 2, right? Alerus actually benefited from the confusion there and got acquittals on a bunch of stuff that he wouldn't have otherwise gotten acquittals on, at least arguably. So, I mean, one argument that we're going to make in the future is basically if you look at the new model instructions on this, it says, yeah, the jury is supposed to be instructed with things like, you have heard, he's been charged with 1 count of sexual abuse of a child. At trial, you have heard evidence that he has been accused of 5 acts of sexual abuse of a child. Act 1, Act 2, Act 3, Act 4, Act 5. You must be unanimous as to which of these 5 acts he actually committed, right? Is that actually something that a defense counsel wants, right? The problem is that that's true from Alerus to begin with, right? So the sort of long answer is we have sort of long-term strategies we want to push up against this, but short-term, this is the #1 most likely way you're likely to see an unnecessary reversal. So what can you do to prevent your case from becoming the next reversal? One suggestion that I saw in a recent trial record that I thought was helpful, I don't know how effective it'll be, but I wanted to lay it out for people. This is from an actual district court judge. The other way to solve this is to just have the appeals court give us some of its excellent hindsight. And then we would know because it always seems so clear to the appeals court what we should have done. I promise this is an actual statement from an actual district court judge who will remain nameless to protect them from the wrath of their appellate colleagues. But barring getting some of that excellent hindsight, what can we do? So the first step to dealing with a unanimity problem is identifying it. And here's, I think, the best way to go about conceptualizing this in a practical way. First, you look at what specific act forms the basis for the charge. And that is going to be defined by the governing statute, right? So say in homicide, right, causing a death is going to be the act that triggers the charge. In so many of these sexual cases, it's going to be an act of sexual touching, right? So if you have 1 act of sexual touching, 2 acts of sexual touching, those are going to be independently chargeable. In other circumstances, however, it may be a much broader set of circumstances. Say, schemes or artifice to defraud. The chargeable act in a circumstance like that might be the entire scheme or artifice. So I have one scheme going on over here. That's one act for purposes of the statute. I have a second scheme over here. That's a second act for purposes of the statute. The only way to kind of deal with this specifically is to think about what exactly is the crime that you are charging and what specific act is alleged in the controlling statute. Then you think about, is it possible based on the facts before you that more than one chargeable physical act occurred? Take another example that's come up in the case law, obstruction of justice. Obstruction of justice, removing a piece of evidence. Throw away my phone, I'm gonna hide my water over here. Two physical acts, right? And so one way you can sort of discipline yourself in this is when you're thinking about how you charge this, and I know some jurisdictions, I see Jeff Gray over here, some jurisdictions I think have moved in the direction of rather than just quoting the statute, but specifically identifying the physical act. So count 1, sexual abuse of a child, to wit, touching of X body part on Y date. Count 2, sexual abuse of a child, touching of this separate body part on this separate date. And I see Jeff nodding, right? These sorts of things are going to help discipline you in making sure that you're identifying a unanimity problem. So if you have a possibility that there is more than one chargeable physical act, if so, you have a unanimity problem. So let's take a look at an example I mentioned before, State versus Sissel. So this is a case, Sissel's prosecuted for DUI. And so what he's prosecuted under, the statute requires proof that he operated a vehicle while either having a BAC of 0.05 at the time of a subsequent chemical test, while being incapable of safely operating a vehicle, or having a BAC of 0.05 at the time of the operation of the vehicle. 3 separate ways in which he can commit this DUI. So, question: does this create a unanimity problem? Right now you've spoiled it. I've spoiled it. Does this create a unanimity problem? I see no. No, why not? You're shaking your head back there. Someone who shook their head back there, tell me why not.
Those raise theories of how people do the test. They're not separate, but acts on that.
Right. So the answer for those listening at home is those are all basically theories of how he committed the same crime. They're not separate acts of conduct. Another hand over here. Right, and then the additional answer is you couldn't charge him with 3 separate DUI counts even if all 3 of these apply, right? You're not going to be able to come in and say, not only did you have a BAC of 0.05 at the time, and you were impaired, and you had a BAC over 0.05 at the time of a later criminal test, so we're going to charge you with 3 counts of DUI based on these facts. And that's the conclusion that the Utah Court of Appeals comes to here. They hold that there's no unanimity problem, or at least not one so obvious that counsel was required to object, right? As in so many of these cases, this is raised through ineffective assistance of counsel. Counsel could have reasonably concluded that the case involved not 3 separate acts, but 3 alternative means of satisfying the element of being under the influence. So the takeaway here is because the state could only charge 1 crime based on 1 act, competent counsel could have believed there's no unanimity issue. So again, this is your sort of heuristic. Identify the exact physical act under the statute. Ask yourself, is it possible that more than 1 chargeable physical act occurred here? If so, you have a unanimity problem. What do you do once you've identified a unanimity problem? Then you give a MUJI. So in past years, we had a bunch of suggested language that we were trying to offer for people. Since then, the Rules Committee has come down from the top of the mountain and bestowed upon us a whole series of model Utah jury instructions dealing with various unanimity problems. These are all reproduced here. I'm not going to read you a whole bunch of jury instructions out loud now. I don't think that's a useful use of your time, but just be aware that you have your sort of standard MUJI instruction 216 that deals with unanimity in your mine run sort of cases. And then you have separate special unanimity instructions, single offense committed in more than 1 way, multiple offenses with identical elements, and evidence of occurrence, of more occurrences than charges. Give these appropriate instructions if you've identified a unanimity problem. Last point too, there are sort of weird in-between cases. If you come up with a kind of a weird charge where it's not clear what's chargeable or what needs to be proved unanimously and what doesn't, reach out to us in appeals. We have a number of people who've worked on these issues now over several years, and we'd be happy to consult with you on that.
Okay, so an online question or an emailed in question. Could this issue be remedied by using a special verdict form requesting the jury on making a finding of guilt on each count, then indicating or checking a box for the specific act?
Yes, if the special verdict form is written correctly, right? So that's the problem is if you say, all right, we have two different charges of sexual abuse. Charge number 1 deals with the acts that occurred on Monday. Charge number 2 deals with the acts that occurred on Tuesday. Well, if 3 separately chargeable physical acts occurred on Tuesday, then the special verdict doesn't fully remedy the problem, right? So yes, it can. And actually, if you look at the model Utah jury instructions, they really recommend a special verdict, but you still have to, in order to craft that special verdict, you have to be aware of what the sort of underlying principles are so that you can craft it accordingly.
Okay, another question specifically about DUI. If a person drove their vehicle, then stopped and got out, then got back in and drove again, is there a unanimity problem there?
I think there would be, because you'd have 2 separate acts of physical operation.
Yeah, so they ask, would I have to charge 2 counts of DUI or instruct the jury they had to choose which one?
You would not necessarily have to choose 2 counts, although you could, but you would have to instruct the jury as to which, to be unanimous as to which of those 2 counts occurred. And you would also, by the way, you might have to deal with like a Rule 404 problem as well, right? So if you have 1 act of driving, it's interrupted, and then a 2nd act of driving, or in the language of the statute, of operating or being in actual physical control, and you've only charged 1 of them, the other is technically an uncharged act, right? And so Rule 404 principles would apply. You may be able to argue, and I think depending on the facts, in a lot of cases that it's sort of, they're intrinsic to one another, because if, say somebody is drunk driving in a car, gets out, runs away, jumps into another car and keeps running away, that's all part of the same sort of general chain of events, and so they're probably intrinsic to one another. But yes, the short answer for unanimity purposes is yes, the jury likely does have to be unanimous about that, because each of those would be separately, independently chargeable.
You see any other questions? If not, I have a question.
Yes, go for it.
Okay. We talked about separate acts that can be charged as separate counts, but what about an issue that's come up in our office, Utah County, is what about when you have different ways, different factors that relate to the degree of offense or that are sentencing factors, aggravating factors, let's say. So like one example is with theft. The degree of offense depends on multiple factors, and you can have second-degree felony, right, if it's an operable motor vehicle or if it's a certain value. And does a jury have to be unanimous on those? Yeah,
and I got another question that may incorporate the same question there, having to deal with assault. So assault refers to commits an act with unlawful force or violence that either 1, causes bodily injury to an individual, or 2, creates a substantial risk of bodily injury to an individual. Does the jury need to be unanimous about that? The way the hypothetical you described and the assault hypothetical, the jury probably does not need to be unanimous because that's a circumstance element rather than an act element. So if the question is, for instance...
are you sure about that?
Well, so let me take the assault one first, because that may be easier, right? Yeah. So if the question is there's 1 act of physical violence, and the question is, well, some jurors might have thought that was... thought that it caused actual harm, and others only thought it caused a risk of harm. It's only chargeable as 1 act. And so at least under cases like Sissel, it's not going to be ineffective assistance of counsel. You could make an argument if the claim were preserved that the jury does need to be unanimous, because there's some sort of loose language in some opinions that says that the jury needs to be unanimous as to each element. And if you have a circumstance element, then maybe arguably they need to be unanimous about that. But I don't think you're going to get an ineffective assistance of counsel claim under those circumstances, because they're not going to be separately chargeable crimes. At least that's what I take from Sissel. The hypothetical you posed about...
Yeah, I think when you get to degree of offense or sentencing, if you can get a different sentence based on...
That may be true, actually, because then it's
I'm thinking
an Apprendi problem.
Apprendi or
yeah, it's an
Alien
Apprendi problem. So just to take a step back, the question he's asking is, all right, yeah, what if there's a dispute about whether there is an act that was sufficient to elevate it to a higher level of offense? Yes, you would need to be unanimous as to that, although even then it would depend on how it's presented, right? Because you're already usually going to be giving I would hope, a special verdict form if it's a true Apprendi element, right? The jury is going to be unanimous not only that they committed the underlying act, but also that they committed the additional act or about the presence of the additional circumstance that elevates it to an additional.
Yeah, the safe thing, I think, is to require the jury to be unanimous if you've got multiple instances there. Okay, we're going to move on. Or is there more questions?
Yes, so question, if a defendant is charged once, but the act is for touching breasts and buttocks in one instance, does the jury have to unanimously agree on whether it was the breasts or the buttocks? The answer is yes, the jury does have to unanimously agree as to whether it was breasts or buttocks, because in our view, each of those touchings is independently chargeable. And so the jury does need to be unanimous about that. We had the question about the special verdict form. And then we had the question about multiple aggravating factors. Should the special verdict form be used to identify which aggravators were found by the jury? He said, that's a tougher question. The better practice is probably just to do it anyway. Because there are other benefits to doing that as well, right? If one of those, if they later come forward and say the evidence was, there are 3 aggravating factors presented, the evidence was insufficient as to one of them. If we have a special verdict form saying, well, yes, but the jury independently found the other 2 were proved too, then that makes it way easier for us to defend on appeal. We can just say, fine, toss one out. There are 2 that are independent to support the verdict.
Yeah. Just make sure that every instance that you've got on your special verdict form, there is sufficient evidence to support that. Okay. You've had your fill of unanimity, so let's move on to self-defense and special mitigation. Okay. This is State versus Hernandez. Hernandez claimed that he stabbed his friend to death because spirits in his head told him that his friend was going to sacrifice Hernandez's newborn son to Santa Muerte. This is the first time I've encountered Santa Muerte, but apparently it is a Santa Muerte is a Mexican folk saint that if you make certain offerings to Santa Muerte, you could get favors, like a better job, or find romance, or win the lottery or something. So anyway, this was Hernandez's claim, and argued that he was entitled to instructions on both self-defense and imperfect self-defense. So he wanted self-defense, imperfect self-defense, defense of others, and special mitigation. Now, of course, self-defense, imperfect self-defense, defense of others, those all require a reasonable belief that the force is necessary to defend against imminent unlawful force. And to be entitled to a special mitigation instruction, you have to act under a delusion that is attributable to a defined mental illness. The delusion has to provide a legal justification for your act, and your actions in light of the delusion have to be reasonable. So here, the holding is the trial court properly denied the requested instructions on self-defense, imperfect self-defense, defense of others, and on special mitigation, because there was no evidence of any imminent harm here. And there was no evidence that the delusion that he had, that his friend was going to sacrifice his infant son to Santa Muerte, that mistakenly gave him the impression that there was some imminent danger to either himself or his son. So if you have these issues come up, make sure you understand the standards, and that you can use this case as a good example of when, if you've got a question about imminency of the harm, here's a good example of when the harm was not imminent. Then in State versus Johnson, here's a case where the defendant was entitled to the instructions, but I'm still trying to figure out why that's the case. But we'll watch this little clip first.
This is my goddamn motherfucking house.
So State versus Johnson is two guys fighting on the porch. And what happened is Johnson, who's the homeowner, and the victim, they're arguing over a winning gambling ticket, which I didn't know that we had winning gambling tickets in Utah, but apparently we do. Supposedly the victim had stolen Johnson's winning gambling ticket, and the victim was upset, and Johnson said, "Go away and never come back." But the victim came back anyway, and he was really angry, and he's yelling, and he's pounding on the house, and he's pounding on the door. And so, of course, Johnson, who's in the house, he goes and he gets his gun, and he goes to the front door. There's two doors. There's a screen door and an inner wooden door. The victim has opened the screen door, and Johnson opens the inner door, and he's holding the gun down at his side. They continue arguing, and then the victim, according to Johnson, he backs away, and either he lets go of the screen door or he tries to slam the screen door, and Johnson raises his arm that's holding the gun to block the screen door. This is his account, and the gun fires and kills the victim. So Johnson then loaded the victim's body into the victim's car, drove it to a church parking lot, and abandoned it, just like you do when you're acting in self-defense. He told the neighbor that he was going to jail because he'd killed a man, and he denied any involvement to the police. And then, initially he denied any involvement, but then he came around and said, well, okay, it was an accident. Johnson's son was interviewed at the CJC, and he reported that Johnson thought the victim might have a gun because the victim was bipolar. And the victim had started to attack Johnson when Johnson opened the inner door, and Johnson thought that the gun safety was engaged. And that CJC interview was played at trial. So Johnson requests instructions on perfect and imperfect self-defense. The trial court denies the request because in the trial court's mind, and I think this is right, there's no evidence of an imminent risk of death or serious bodily injury to Johnson or to his kids that are inside. But the holding in Johnson is that he was at least entitled to an instruction on imperfect self-defense. Perfect self-defense, of course, is if you have a reasonable belief that deadly force is both necessary and legally justified. Imperfect self-defense, you have a reasonable but a mistaken belief that the circumstances provided a legal justification. And so the appellate court here is saying he was at least entitled to an instruction on imperfect self-defense. And the evidence that the court seizes on is the son's report that the victim was moving to either attack or punch Johnson immediately before the gun discharged, and that everything just happened in the blink of an eye. It happened really quick. And also the fact that Johnson had said he feared that the victim was threatening the safety of his children who were in the house. So to me, this seems like a pretty weak case of self-defense, especially where the defendant's initial statement and his defense to the police or at trial is this was just an accident. I thought the gun was on safety. But be aware of this fact pattern when you're dealing with requests for self-defense, or especially imperfect self-defense. Any questions? Okay.
I did get another unanimity question about assault, and I was giving a written answer, but I'll discuss it in front of everybody as well. What if you have an assault where you have someone who strikes a victim multiple times? Is that creating a unanimity problem? We're not discussing it in the slides, but take a look at State versus Mayorga in the materials. The short answer is we don't have clear guidance yet, but because the court there finds that there's no prejudice and doesn't address whether the unanimity instruction was required. But the safer approach would be, well, look, if I punch poor Chris over here 3 times, that could be independently chargeable as 3 separate acts of assault, and so you need to give a special unanimity instruction for it, that the jury needs to be unanimous as to which punch occurred. Probably instruction 432. Mayorga is a case where they basically say, well, we're not going to address that because we think it's really unlikely the jury would have failed to reach unanimity on these facts because they're basically all supported by the same evidence. But the better practice there would be to give a special unanimity instruction. Okay, I said before that Aliris and unanimity is sort of the #1 way of losing a conviction that could have been easily saved. We're going to talk about the #2 way in recent years, which is dealing with self-representation.
Kermit the Frog representing himself on a murder charge.
Well, golly, I understand that the prosecution has presented a really compelling case. And obviously, Fozzie Bear was a close friend.
Oh, no.
But ask yourself this question. If I were to be the one that killed Fozzie Bear, why would I have recorded going to see him alone that night? Wouldn't I have wanted to cover that up? Doesn't this speak that I've been framed? My name written in the ledger of the motel was written in pink glittery ink. Ladies and gentlemen of the jury, you've been watching me in a really toxic situation for decades. And nobody's done anything. I understand there's a gender dynamic, but Miss Piggy is 4 or 5 times my physical size. She's incredibly strong, and I know that she's in the courtroom.
All right, so let's talk about self-representation. So a little bit of background on State versus Luck. This case just came down within the last couple of weeks. So the facts here are pretty lengthy, and I'm not going to give you all of them, but I want to give you at least a little bit of a flavor of them. Luck is charged with stalking and represents himself at the preliminary hearing. At the prelim, he asks only 2 questions for which the court did not sustain an objection. So almost everything he says is improper and objectionable. He then asked to call 2 witnesses at the prelim, but he hadn't subpoenaed them, and he said he didn't know that he had to. The court offered him an attorney, but Luck said that he didn't want one. After the bind over, the court asked Luck if he had any assets, presumably to see if he qualified for appointed counsel. Luck and the court then had a very lengthy exchange where he made it abundantly clear that he did not want an attorney. He compared having an attorney to slavery, said he'd been through the system twice. The court emphasized that an attorney would be helpful, but he still said no. Luck's mom even interrupted at one point to tell him to get an attorney, but he still refused. And bless the trial judge, who said, you know, moms can be pretty smart about things. Maybe you should listen to your mother about this. During a second pretrial conference, the court said it's never a bad idea to have somebody who's trained in the law, who understands the procedures. Luck said he still didn't want an attorney. The court brought this point up again at several more points throughout the trial, telling Luck at one point, I really think you're making a mistake by not having an attorney represent you at trial. Luck repeatedly said no. The district court then appointed standby counsel for the trial itself, and standby counsel participated in the trial to some degree. Luck is convicted, and then during sentencing investigations, he said some really strange things. I was 12,345 days old when I experienced death while meditating, and I haven't had a thought since. I am what I've always been, a divine mirror of God. God doesn't judge anybody because he is your heartbeat. Luck then appeals after having been convicted, and he argues the court the court erred by failing to ensure that his waiver of his right to counsel was knowing and voluntary. So abundantly clear from this record, he wants to represent himself, right? The Court of Appeals reverses for structural error. The Court of Appeals says, our cases have set out two paths under which a court can find the defendant's waiver was knowing and intelligent. One is an on-the-record colloquy under State versus Frampton, and the written materials that are going to be posted on the website are going to include the full details of what's in that Frampton colloquy. And the second is a de novo, so that's not complied with here. We don't have a full Frampton colloquy. The second then is a de novo review to ensure waiver was knowing and intelligent. The court says compliance with the Frampton colloquy is not mandatory, but it's preferred. And here, the district court left some of the Frampton stuff out. So it was very, very clearly communicating that it thought it was a bad idea for him to represent himself, that it would be better if he did. But he never asked whether Luck had represented himself before. The judge never warned Luck about the maximum punishment, that told Luck that Luck would have to testify question by question rather than just getting up and telling their story in front of the jury, and did not directly ask whether the choice was voluntary. The court also didn't have a sort of two-way interaction characterized by questions and answers. They're sort of talking at each other when they're engaged in these hearings, some of which may be because Luck doesn't really want to have a two-way conversation with the judge about this. But the Court of Appeals says this leaves the Court of Appeals unconvinced that he understood the seriousness of the charges, the maximum penalty, and that the trial requires a knowledge of technical rules and not just telling your own story. The court then finds this to be structural error, meaning it doesn't look at prejudice at all. It's automatic reversal and sends it back down. So this is a case, again, where it is abundantly clear that the defendant wants to represent themselves. The court gives him what he wants, and the conviction is reversed anyway for structural error. So a couple of takeaways from this. One is that this may not be the end of this case. Our office is meeting next week to discuss whether we want to take this up any further. We actually have a concern that you have a constitutional right to counsel, but you also have a constitutional right to self-representation. And we're actually kind of worried that the Utah courts may have been so worried about the right to counsel that they're ignoring the countervailing right to self-representation. So this could actually cause some constitutional issues for defendants. So this may not be the end of the case, but the short takeaway for everybody who's here is if a defendant wants to self-represent, insist that the trial court give the Frampton colloquy. Even if the defense hasn't raised the issue, even if the trial court hasn't raised the issue. And as I said before, the Frampton colloquy, you can look up State versus Frampton. Just remember, I want you to show me the way. Think of, no Peter Frampton fans here. That's an old joke even for me. Insist that the court give a Frampton colloquy, because this is now, at least in past cases, we were able to argue, well, maybe there's no prejudice. Luck shuts that down. This is now automatic reversible error if the district court gets the colloquy wrong. So even if the district court doesn't want to give the Frampton colloquy, insist. We had a case during our materials last year where the district court said, no, I don't think I need to do that. You have to insist. And if you need to, say the funny-looking balding guy who's not at all sensitive about his receding hairline, who talks at the UPC conference every year, said that you have to give a Frampton colloquy, otherwise this may be automatic reversal. Like I said, I have some questions about the reasoning that Luck gets to. But at the end of the day, I think the way our courts of appeals are looking at this is an easily preventable error. Just give the colloquy and you'll be fine.
And then I have just in one of the cases that I reviewed, State versus Campbell is just kind of an addendum to all of this about self-representation. Campbell was also a self-representation case. And this is a case where the defendant just could not make up his mind. He kept saying, I want to represent myself, but then the court would say, okay, are you sure? Have you talked to your counsel about this? And he'd go and talk to his counsel about it, and then he'd withdraw his request for self-representation. He did that several times, including in the middle of his own counsel, if I'm remembering right, I think his own counsel's opening statement. He says, Your Honor, these guys aren't representing me very well. I want to represent myself. The court takes a recess, says, go talk to your counsel about it. He comes back in and says, no, they can still represent me. So a trial court can defer ruling on a request for self-representation, and encourage the defendant to consult with his counsel. And then, if the defendant comes back and says, no, I still want to represent myself, do the Frampton colloquy, make sure you insist on that. But if he comes back and says, no, okay, I'll stick with my counsel, that's okay too. Just make sure that the court has explained, when he says go talk to counsel, when the court encourages defendant to go talk to counsel, make sure the court says, if you still want to represent yourself after you've talked to counsel, I'll entertain your request. So just be aware of that case on self-representation. Okay, we're going to move on now to extreme emotional distress. This is State versus Smith, and it's a divorce. It's a situation involving a divorce where extreme emotional distress often comes up, but hopefully this case shuts that down. After planning to leave for months, the wife calmly tells her lazy, hot-tempered husband that she's finally leaving him. And in response to that announcement, Smith went to his closet and he grabbed his car keys. Now his gun was there in the closet as well. He didn't grab his gun. He grabbed his car keys. He drove to the bank. He withdrew $15,000. I guess maybe because he knew he was going to need to retain a lawyer. I don't know. Then he goes back home and he finds that the couple's children and some neighbors are there. There's a moving truck and they're loading stuff into the truck. And so then he goes and he gets his gun and he goes into the bathroom and loads it. And he explains that at that point he was thinking of killing himself. And then with the loaded gun, he leaves the bathroom, he goes into the backyard, or wherever one of his adult sons was as they're trying to move mom out. And he says, are you okay with this? Are you okay with her leaving me? And he says, yeah, I'm okay with that. And so then he walks into the kitchen, he sees his wife standing there with her back to him, and he shoots her 7 times in the back. This happened 25 minutes after the wife's initial announcement that she was leaving him. So at trial, Smith requests an instruction on extreme emotional distress, and the trial court denies it. This is down in St. George, I think. And to quote the trial court judge, Judge Wilcox, he says, look, people get divorced all the time and don't end up dead. So that's a nice... That's a nice fact that you can quote if you're dealing with this. So on appeal, it's affirmed. Extreme emotional distress is an overwhelming reaction of anger, shock, or grief that causes a defendant to be incapable of reflection and restraint. And it causes an objectively reasonable person to be incapable of reflection and restraint. So there's both a subjective and an objective component to extreme emotional distress. You actually have to be experiencing this extreme emotional distress, and an objectively reasonable person would experience that. And it requires also a highly provoking act immediately preceding the defendant's actions. And I think, there's been a lot of extreme emotional distress cases over the years. I think the overhaul of the statute in 2019 has helped clear some of this up, and hopefully this case does as well. What the court holds, they agree with the trial court. First of all, there was no highly provoking act here. Again, people get divorced all the time without ending up dead. And the fact that he shot his wife in the back while she's in the kitchen, just standing there, that's the antithesis of a highly provoking act. And then the Court of Appeals goes on and says, even if the wife's announcement were highly provoking, you've got 25 minutes where he's reflecting and processing what's going on. So that did not qualify as extreme emotional distress. David, you're up. Oh, no, wait, sorry. This is my slide still. I was looking at the next slide. There was also an issue about a continuance in Smith. Smith had said, right as trial starting, he said, not only, Your Honor, do I want an extreme emotional distress defense, I also want a continuance so that I can call an expert to testify about extreme emotional distress. There was no problem in the trial court's denial of that continuance because, first of all, he wasn't entitled to the defense. And then he also failed to identify any specific witness he was going to call, how soon that witness would be available, and proffer the substance of that testimony. It's not enough to get a continuance to just say, Your Honor, there's a really big issue and I need to get a witness to be able to testify about it. You've got to identify those specifics for the trial court and explain, especially if it's on the eve of trial or during trial, how you're going to be able to get that witness there soon and how it's going to help your case. Okay, now you're up. Sorry about that.
Great. Two other questions that I got while we were waiting, or comments. One was just having talked about imperfect self-defense, it might be worthwhile to emphasize the importance of an accurate imperfect self-defense instruction if one is given. It's a tricky instruction, and poor instructions keep reoccurring. That's true, and I would say from an appellate standpoint, spending an extra couple of minutes to look through your instructions, particularly on the elements of the offense, is going to be well worth your time because that's another frequent source of reversible error. Another comment, can prosecutors also guard against unanimity issues by either having more specific charges, like using a to wit, or moving to amend the charges to conform to the evidence of trial? The more specific you can be about what occurred and in the charging document, ideally, the better it is going to be for everybody. The one other thought I had about the spousal extreme emotional distress point, I feel like I often am in the point of view up here of saying, when in doubt, just give the instruction. This may be a case where I'm totally fine fighting the instruction. Like if someone's saying I'm leaving you and their husband responds by killing them, I'm totally fine going into the Court of Appeals and saying, no, divorcing somebody is not a highly provoking act. It happens all the time. Leaving an abusive partner is not highly provoking. It's what people should be doing, and we should be protecting them. And so you're not entitled to the instruction. So if you all want to dig in your heels in a case like that, we'll have your back on appeal. This is going to be a little bit quicker. Let's talk about flip-flopping. So this is State versus Rippey, which deals with guilty appeals. Guilty pleas, excuse me. So this is really quick, but so attempts to withdraw a guilty plea were formerly governed by Utah's plea withdrawal statute. This is Utah Code 7713-6. And any motion to withdraw a guilty plea under this old plea withdrawal statute had to be made before the sentence was announced. And then any later attempt to withdraw the plea could only be raised in post-conviction. And the idea behind this was to sort of prevent the buyer's remorse problem, where people say, oh yeah, no, I've got this smoke and plea deal, I'm going to agree to it. Oh wait, now that I'm actually getting to the point where I'm going to have to face those real consequences, never mind, I just don't want to have to face consequences. I can get some feedback here. See if I can turn that off and if that helps. So the goal is to sort of prevent the buyer's remorse problem that we see so frequently when it comes to guilty pleas. So that's what this plea withdrawal statute was intended to do. State versus Rippey comes down in December, and it says that plea withdrawal statute is unconstitutional under Utah's separation of powers provisions. It's an unconstitutional interference with the judiciary's power to create procedural rules as laid out in the Utah Constitution. So, I don't want to go into a whole bunch of the details about how the court got there. You're not likely to see a lot of these challenges anytime soon. But the takeaway is the old plea withdrawal statute is gone. The prosecutorial community, our friends in SWAP, tried really, really hard to get the legislature to re-implement the old plea withdrawal statute in this past legislative session. But that required a vote by a 2/3 majority, and we couldn't get the votes. And so we had to settle for a compromise. So in the aftermath, we have a new regime in Utah for dealing with guilty pleas. Under the sort of compromise approach we have now, the plea withdrawal statute is gone, and plea withdrawal is now governed by an updated version of Utah Rule of Criminal Procedure 11. So the new rule under Rule of Procedure 11 is that a motion to withdraw a guilty plea should be filed before the sentence is announced, but if it isn't, the defendant may still challenge the plea in accordance with the preservation rule or an established exception to the preservation rule in a direct appeal. What this likely means is that it's going to be easier for defendants to try to withdraw their pleas. What this likely also means is that we will see more plea challenges raised on appeal, and you'll get more calls from my office saying, hey, look, we got a motion for a remand for ineffective assistance of counsel regarding the plea filed under Rule 23B. We're going back to the district court. Buckle up. We're going to go have a hearing about this. So takeaways from this. So first takeaway, if the defendant pleaded after Rippey came down and they seek to withdraw their plea, follow Rule 11. We have a new rule that's been amended. That's going to apply to all cases going forward. That's first takeaway. Second takeaway, if the defendant pleaded guilty before Rippey and they seek to withdraw their plea now, contact the AG's office if you haven't already. We've been sending information around the UPC server, listserv and everything about this. But if you have someone who, say, they pleaded guilty 10 years ago, and now they filed a motion to withdraw their plea saying, well, Rippey just came down, so now I get to withdraw my plea, contact us. Even if the plea withdrawal statute doesn't apply anymore because Rippey struck it down, we still have procedural defenses in the district court. We can still say, well, look, yeah, you pleaded guilty, but you pleaded guilty 10 years ago. The district court lost jurisdiction after the case was finished, and now you can't just come back and start filing motions again. So some of the samples of this have been circulating on the UPC email server or email list. But if you have one of these cases, somebody tries to resurrect a long dead plea deal, reach out to us. We have some model briefing we can send to you. The third takeaway is just sort of let the AG's office and SWAP know how this goes. We're really worried that this sort of loosening of the rules around plea withdrawal to make it easier to withdraw a plea is going to lead to more plea withdrawals and put a significant burden on us and on trial prosecutors. So we're worried about it. The defense was not. And there was sort of an attitude, I think, at least among some members of the legislature that sort of, well, if this continues to be, if this becomes a big problem, come back to us and maybe we can revisit it. So if you're seeing waves and waves of plea withdrawal motions, let us know and let SWAP know so that we can try to look at it again in future legislative sessions.
And I think the critical thing is when they filed their motion to withdraw, because we had about a month of time when there was no deadline on motions to withdraw guilty pleas. After Rippey came down, which was, I think, December 27th, well, I guess it's more like 2 months. Between December 27th and then when the legislature finally enacted SJR 10, which amended Rule 11 to put the deadline back into the rule. I know there's defendants that have filed motions to withdraw in that window on pleas that are decades old and said, hey, there was effectively no deadline, and so therefore I get to move to withdraw my plea. And I think, like you said, David, they need to let the AG's office know about that. We can raise procedural arguments to that.
Yeah, and we think we have a strong procedural argument for that because Rippey himself made that argument. Rippey raised the issue both as if it were a preserved issue and as an ineffective assistance of counsel claim. And we opposed him raising it as preserved issue, saying, no, the district court lost jurisdiction after your, after your case ended. And the Utah Supreme Court agreed with us in a written order. The problem is they did not publish that order. So if you get one of these cases, we have briefing for you, and we can send you a copy of the Supreme Court's unpublished order rejecting this sort of attempt to resurrect things months and months or years and years after the cases became final. But you're not going to find it on Westlaw, so let us know.
Yeah. Unfortunately, I think the thing we're going to see now, though, is those people that filed a motion to withdraw in that window, if the trial court agrees with those procedural arguments, denies the motion to withdraw, then you're going to see an appeal saying, hey, Rippey says I get to raise this under plain error or ineffective assistance of counsel, and we'll have to deal with that. I think one argument to that is, one response to that is, you can't use that as an end run around the Post-Conviction Remedies Act, which is what should govern these charges, or these situations.
But just keep us up to date about how this unfolds, because we may be able to revisit this.
Any questions on that? Okay. We're close to our break.
You want to stop for a break 1 minute early?
Yeah, I think we should do a break.
All right.
Okay, we will continue on with statutes of limitations. Two cases for you that talk about statute of limitations. One, turn this off again. One case where the statute did not bar the prosecution, but in State versus Begay, the first case I'm going to talk about, the statute did bar the prosecution. So here's the background of Begay. In 1998, the victim's friend is being interviewed by police. She reports to police that the victim raped her. And then the officer says, has he raped anybody else? Or has he had, are you aware of any sexual misconduct that he's engaged in with anybody else? And the friend said, well, kinda, yeah, but I don't want to break confidentiality. So the officer then says to the friend, well, the law requires you to report sexual abuse, and especially if the victim is under 14. And so at that point, the friend says, well, okay, in that case, Begay also had sex with my friend, who happens to be the victim in this case, and she gives the victim's name and birth date. So the friend reports about sexual abuse that she suffered at Begay's hands, and then also that the victim in this case, that Begay had sex with her when the victim was 13 or 14. Police had the name and the birth date. So the officer goes and interviews Begay, and he admitted that he had consensual sex with the friend, but he denied having sex with the victim in this case. And so the state charges Begay with rape of a child for the friend and prosecutes that, but they don't charge anything related to the victim. So in 2021, the victim in this case contacts the police. And let me just go back again. Yeah, so it was 1998 when the report happened. 2021, the victim contacts the police and says, hey, Begay also raped me. And so the police re-interview Begay. He admits to having consent. This time he says, yeah, I had consensual sex with her. And so they charge him with rape of a child for the victim in this case that would have occurred in 1996 or 1997 when she was 13 or 14 years old. But at that time in 1996, the statute of limitations was 4 years from report. So the issue in this case was the friend's disclosure to the police, was that a report to the police? And the Court of Appeals says that it was. There was a report in 1998 when the friend said Begay had sex with the victim in this case and gave the victim's name and birth date. So State versus Green defines what constitutes a report to police. A report is something that is a discrete and identifiable oral or written communication. It's intended to notify law enforcement that a crime has been committed, and it actually communicates information that bears on the elements of a crime and that would place the law enforcement agency on actual notice that a crime had been committed. So the state had argued that, well, yeah, the friend was talking to police and talked about the victim in this case who also had sex with the defendant, but her original intent was just to report a crime involving herself. But that intent in going to the police in the first place, that was not controlling. What was controlling is what was the intent when she told police about what Begay had done to her friend? What was her intent in making that statement to the police? And because the police had said, was there anyone else? The court found that that was a communication with the intent to inform law enforcement of a crime. And then the other argument in this case was, well, all the friend said was he had sex with her. They didn't identify any specific crime. That didn't go anywhere. Begay clarifies that when a person makes a report, they don't have to identify any specific crime, just enough information to put law enforcement on notice that a crime has been committed, that there's something that they need to investigate. So that's Begay. But the second case on statute of limitations is State versus Winter. And the point that I want to make with State versus Winter is you can extend, the legislature can extend a statute of limitations that hasn't expired, but it can't resurrect a statute of limitations that has expired. You can't bring it back. You can't bring a charge back from the dead once a statute has expired. So in this case, this is a case about extending the statute of limitations. Winter sodomized his 5 or 6-year-old niece between 1988 and 1990. The victim told her family about the abuse when she was 12, so about 6 or 7 years later, but nobody did anything about it. So we don't have a report to law enforcement, we just have a report to family. We don't have a report to law enforcement until 2019, and then that is when the victim's charged in 2019. So in 1988, when the crimes occurred, the statute of limitations was 1 year from report, so long as there's been no more than 8 years that have elapsed from the commission of the offense. But then in 1991, the legislature extended that deadline to 4 years from a report to law enforcement. So that's the triggering event. And then in 2008, completely removed the statute of limitations at all. So here in Winter, the prosecution was timely because the statute of limitations extended and it had never expired before it was eventually eliminated in 2008. Back when the crime was committed in 1998, the state still had 8 years under that statute to prosecute, so it had until 1996. But then in 1991, we've got that extension of the statute to 4 years from report. And because there had been no report at all until 2019, the prosecution was timely because of that extension. So legislature can extend, but you can't resurrect a statute that's passed. Okay.
So this will be relatively quick. Just a couple of bail cases that I'm not going to bore you with the extensive, weird jurisdictional arguments presented, but I want to flag something for everybody here. So Utah Code, recent legislative amendments in 7720-209 gave defendants a right to an expedited appeal of a pretrial status order that denies bail. And as you may know, if you handle these, in many cases, you don't just have one discussion of bail and then it's over. You may have multiple discussions of bail throughout the course of the case in the trial court. The Utah Court of Appeals, in a case called State versus Gross, and then in subsequent cases, has interpreted this statute to mean that, very, very simplifying it down, that defendants can basically appeal pretty much anything at any time as so long as it relates to bail and they get an expedited bail appeal. We would really like to get this case in front of the Utah Supreme Court because we think the Utah Court of Appeals has taken a really, really broad approach to bail appeals that is leading to a lot more bail appeals and that is leading to a lot of wasted resources that could better be spent just moving these cases forward. But for weird jurisdictional reasons, that's really hard to do because so many of these cases later become moot. They're hard to get all the way to the Utah Supreme Court in time to get a decision on them. So this is less sort of a life lesson for you all and more like a request from our standpoint in the appeals division, is please reach out to the Attorney General's Criminal Appeals Division immediately if you have a defendant who files a bail appeal in a first-degree felony. If you have a defendant who files a bail appeal in a first-degree felony, those cases have original jurisdiction in the Utah Supreme Court, and so we would like to, the next one that comes along that we can catch, we would like to grab it and tell the Utah Supreme Court to hold on to it. The problem is that we need to tell the Utah Supreme Court to do that within 7 days after the appeal being filed. And we don't generally have time to review cases 7 days after the appeal has been filed. As a matter of fact, it's generally sort of not in our interest to do that because a lot of times people may withdraw their appeals or we don't know what the issues are going to be yet, so we're not going to look at the record. So you all are in a better position to look at this than we are. If you have a first-degree felony case in which somebody appeals a bail determination, flag it for us, send it to us so we can review it for a potential retention in the Utah Supreme Court. Do you want to talk briefly about Gross still? Yeah.
Just wanted to highlight Gross as a good example of, let me get on the right slide. Okay. It's just got a really good fact pattern and analysis about what constitutes substantial evidence to support the charge and substantial evidence of dangerousness. So if you're dealing with a bail issue and you need a case to cite, Gross is a good case that you can hopefully liken some of your facts to. There was substantial evidence to support the charge in Gross. He was a registered sex offender who was trying to lure children at the playground into his black Tesla. When some parents noticed and intervened and got a partial license plate, Gross then went home and he told his wife that police were coming to arrest him. And one of the witnesses at the playground identified him in a lineup. That's him. And so that constituted substantial evidence of the charge. And as for substantial evidence of dangerousness, you've got a sex offender who's escalating his criminal behavior. And the trial court did a good job here of analyzing reasonable alternatives. And the trial court found, and the appellate court agreed, that there were no reasonable alternatives here. GPS monitoring wasn't really going to help much because it wouldn't tell anybody when he was around children. And just requiring a no contact order wasn't going to help where the victim, where he was, trying to get strangers to get into his car. So that's a good case when you're dealing with bail. Okay, Rule 403, State versus Lewis. This is about a recorded phone call. Back when they were engaged, Lewis raped his fiancée while she was asleep. And then years later, after they get married, they have children, and then get divorced, the now ex-wife reports the rape to the police. And in the meantime, there's been a protective order entered against Lewis that allows only written communication about the children with the ex-wife. So investigating this report of rape, the police decide that maybe they can do a pretext phone call with Lewis, and they get the county attorney to agree not to prosecute the protective order violation. And so they go ahead with the pretext phone call. Lewis makes incriminating statements during the phone call, but then he's also hesitant and expressing concern about this whole situation because of the protective order. And that comes across in the recording. So the trial court was furious about how this evidence was gathered and went on and on and on about how unfair this was to subject Lewis to a pretext phone call when there was a protective order in place preventing him from talking to the wife. The trial court found that it suppressed the recording because of the egregiously unfair nature of the investigative techniques. It found that he was not fully at liberty to be able to fully and confidently respond to the wife's allegations, his ex-wife's allegations. And in fact, law enforcement's actions shocked the judicial conscience. They were arbitrary and unrestrained. And if that wasn't enough, it was also, the trial court found the recording is inadmissible under Rule 403. The trial court found that it had little probative value because of his hesitancy to talk, and he raised concerns about the protective order during the conversation. He gave, in the trial court's view, only short responses, and he was responding to leading questions that the trial court found was very concerning. And they were emotionally charged questions. And the trial court also found that some of his answers were ambiguous about whether there was consensual sex or not. So those were all of the reasons that the trial court found there was little probative value. And on the unfair prejudice prong, the trial court really, again, relied on the egregiously unfair investigative techniques, Lewis not being at liberty to fully and confidently respond and refute the barrage of leading questions. And the court was concerned that given the nature of the conversation and it being a conversation that occurred when a protective order was in place, the jury risked being misled and confusing the issue about consensual and non-consensual sex. Unfortunately, that ruling got affirmed on appeal, but in a split decision. Judge Orm and Judge Oliver affirmed. And they point out that while they may not necessarily have agreed with the trial court's Rule 403 ruling, the standard of review is just for abuse of discretion. And that's a pretty liberal standard of review that usually helps the state on appeal, but in this case, it was the prosecution's undoing here. Because review, you have to, the appellate court would have to find that no reasonable judge would reach the same conclusion. And they couldn't say that the trial court abused its discretion here. They agreed that the answers were ambiguous because while he may have expressed guilt about marrying in a religious ceremony that required abstinence before marriage, he made some of those statements about feeling guilty during the conversation, but they agreed that he made no such statements when he was directly accused of the rape, when his wife accused him of raping her while she was asleep. And they also agreed that the need for the evidence wasn't great. They reasoned that the trial court could have removed the protective order before engaging in this pretext phone call, or they could have interviewed Lewis. but they don't recognize that he didn't have to cooperate with that interview, right? That we can't depose defendants. The appellate court also agreed that there was reliability problems with the statement, given the protective order that was in place. And they also felt like on the unfair prejudice prong, it would be impossible to present the recording without also dragging in to the trial evidence about this protective order being entered. So be aware of that fact pattern when you're dealing with Rule 403 issues. I'm sure you're going to see Lewis cited and argued by the defense as to why some of our evidence should be excluded. Judge Tenney did dissent, and his dissent does an excellent job of going through each of the majority's arguments and taking them apart piece by piece. And cert was granted in this case. So this isn't the end of the story, but we've got to deal with it for now. Judge Tenney emphasizes that Rule 403 is a rule of inclusion, and that when a party seeks to exclude evidence under the rule, they have a very heavy burden. None of that case law is in the majority opinion, but you do find it in Tenney's dissent. He finds that there was high probative value because at least some of his statements were not ambiguous, or at least not as ambiguous as the majority describes them. The need for the evidence was high. This was a he said, she said case. And he also points out that the fact that he believed that the wife, the fact that Lewis recognized he was now violating the protective order during the call, and that his wife now had leverage over him, would have made him less hesitant to make the admissions that he made, not more likely to make incriminating admissions. And then finally, he would have found that it was possible to edit the recording so that you could get in the incriminating stuff without dragging in the protective order. But like I said, cert's granted, so stay tuned on this. Hopefully, we can get the Supreme Court to clarify this. But if you get faced with a defense attorney citing Lewis as to why the evidence should be excluded under Rule 403, go to State versus Simpson, which is a more recent opinion from the Court of Appeals. And this case also involved 403 evidence in a sexual assault case. And this time you've got Judge Tenney writing in the majority saying the evidence was admissible. Simpson was an aspiring college football player. He raped 3 women under similar circumstances. The state sought to admit the other 2 victims under Rule 403 to rebut his claim that the victim at trial consented. And the trial court agreed and admitted the evidence, but ultimately only one victim was willing to come forward and testify. And a very important piece of this case, and something that we would advise you to do every time you admit Rule 403 or Rule 404B evidence, is to have the trial court give a limiting instruction. And I think it's very helpful if the trial court gives the limiting instruction right before the witness testifies, and again as part of the closing jury instructions. That was a detail of this case that the Court of Appeals found persuasive as to why admitting that evidence didn't violate Rule 403. So the case goes up on appeal. Simpson only challenges the 403 ruling. He doesn't argue that this was inadmissible under 404B. Like I said, Judge Tenney, this time writing for the majority, he affirms and puts in all of that really great case law about Rule 403 being an inclusionary rule, being a significant burden to get evidence excluded, and points out as why there was strong probative value for this evidence, and why any danger of unfair prejudice did not substantially outweigh that probative value. And an important thing that the trial court didn't do as well as the appellate court wished the trial court had done, but that in analyzing the evidence, the trial court did articulate and weigh the permissible or the probative reasons for the evidence versus the impermissible reasons. The trial court made that explicitly a part of its analysis. So Court of Appeals affirms, like I said, and it also finds that the trial court properly analyzed some of the relevant factors from State versus Shickles. One of the arguments on appeal was, oh, you've got to reverse because the trial court cited these Shickles factors and we've gotten rid of those in Utah and the trial court shouldn't have talked about those. That's not the case. The case law says that the Shickles factors cannot control the 403 analysis, but it doesn't mean that they're entirely irrelevant. So just the fact that the trial court mentioned Shickles and considered some of those factors didn't make its analysis improper. And again, there were limiting instructions that helped mitigate the unfair prejudice. So when you're opposing a Rule 403 motion, rely on Simpson and the case law that it cites. You can distinguish Lewis. I think the way to distinguish Lewis is really to focus on the unique circumstances there of that protective order being in place and that limiting his ability to speak freely. And then make sure that you get limiting instructions. And one of the things that the appellate court pointed out is that a really good limiting instruction is going to identify both the proper reasons that the trial or the jury can consider the evidence and the improper reasons. So it will say something like, you can consider this evidence, but only as it applies to the defendant's claim that the sex was consensual. You are not to consider this evidence as to finding that the defendant has a propensity to commit these kinds of acts, or that somehow if he did it then, he must have done it this time.
Thank you. And yeah, for Simpson as well, also take a look at State versus Green. We now have a depressingly consistent body of law in Utah regarding football player serial rapists. And so I really hope that that does not continue, but based on prior experience, I worry. All right, another case for those of you who prosecute sex crimes, wake up, raise your hand. Keep an eye out. This is State versus Jolly, which just came out recently, dealing with Utah's rape shield rule. So, quick bit of background here. So, the so-called rape shield provisions of Utah Rule of Evidence 412 provide that a victim's prior sexual behavior is generally not admissible in a case involving sexual assault. That should all be familiar to us. That's been the law in Utah for quite some time. Rule 412 also provides an exception where the defendant seeks to prove consent by showing evidence of prior acts of consensual sex between the defendant and the specific victim, right? So if a defendant seeks to introduce this evidence under this exception, then Rule 412 also provides a right to a hearing. So this basically, if you're going to introduce these prior acts of allegedly consensual sex between the defendant and the victim in that case has to be given notice and an opportunity to be heard and to have evidence heard at an in-camera hearing before the evidence is admitted. And the purpose of this, if you look at the rule, is to protect the victims, right? We're not going to just let this sort of evidence in automatically. We're going to give the victim an opportunity to be heard before we let this sort of really embarrassing evidence of prior sexual conduct be admitted. What happens in Jolly is Jolly attempts to take this rape shield and turn it into a sword. So Jolly says, well, there's this rule saying that there's a hearing under 412. So I want to force the victim to testify at the hearing. I'm going to allege that I had prior consensual sex with the victim. And so now I'm going to subpoena the victim to testify at this 412 hearing to allow me to collect evidence to support my claim of prior sexual acts. And the district court agrees. The district court buys off on this rationale over the over the victim's express objection. The district court said, yeah, no, let's hold a hearing. We'll require the victim to testify about all the prior sex that she's had with the defendant, and we'll allow you to subpoena the victim to do that, but don't worry, we'll hold it in camera. The victim files an interlocutory appeal, and the state supports the victim on appeal. Case goes up before the Utah Supreme Court. The Utah Supreme Court says that, look, the district court and Jolly here have fundamentally mistaken the purpose of what a Rule 412 hearing exists for, right? It's Jolly's job to identify the evidence he seeks to admit in advance of a 412 hearing in a way that's specific enough to decide, to allow the district court to decide whether this evidence is admissible. So it's the purpose, in other words, of a Rule 412 hearing is to allow the victim to be heard. It's not to help the defendant to secure his evidence. It's not to allow the victim, it's not to allow the defendant a chance to force the victim to testify. And so the only purpose of a hearing under Rule 412 is to give the victim and the parties a right to be heard before this highly embarrassing evidence is admitted. It's not a discovery tool. The fact that the trial court offered to hold the hearing in camera here, moreover, doesn't mitigate the harm that the victim's going to suffer from this, right? The victim is still going to have to go into court and testify about really sensitive subject matters that are presumptively protected by the rape shield law. So the Utah Supreme Court reverses and says, no, this order is improper. So the takeaways here are really kind of twofold. One is just reiterating that Rule 412 exists to protect victims. It's not a discovery tool. I'm not aware of any other case in Utah where defendants have attempted to use Rule 412 as a discovery tool, but if this is an emerging or potential practice, hopefully this puts the kibosh on that right away. The other point is that Utah appellate courts are actually quite willing to grant interlocutory review to protect the privacy rights of victims. So this is one case that we've had recently. FL was another, in which if you have a victim who you think is being whose privacy rights are being threatened by an erroneous ruling like this, reach out to us. I mean, it seems like our appellate courts have an appetite for hearing interlocutory appeals on these issues, and we would be willing to take them up.
Okay, anyway. Not going to spend a whole lot of time on Lovell, but just highlight it to make you aware, remind you, if you weren't already aware, that evidence of religion, especially in this state, can be sensitive, touchy. I know most of you don't handle capital sentencing proceedings, but that's the situation in Lovell. Lovell had admitted to committing aggravated murder. He admitted that he killed his rape victim so she couldn't testify against him. There's a long and torturous path for this case, but finally, even after pleading guilty and having that guilty plea reviewed twice on appeal, he gets a jury trial, and the jury convicted him of aggravated murder and sentenced him to death again. But at his second capital sentencing hearing, and after over 20 years in prison, Lovell portrays himself as a changed and remorseful man. And he called 3 of his former religious leaders of the prison to testify about his remorse and his changed character. And he called another witness to talk about all this charity work that he's been doing. Here's where we start to get into a problem. On the cross of the very first religious leader, former religious leader that Lovell had at the prison, the state elicited testimony that he'd been excommunicated from the LDS Church, he hadn't been readmitted, and that the readmission request, if he made one, would have to go through the LDS Church's first presidency. The state also elicited testimony on LDS teachings about repentance and remorse, having godly sorrow for sin, and evidence about how disciplinary councils or membership councils in the church work. And again, that the first presidency would have to be the one to decide whether he was sufficiently penitent to be readmitted. The Supreme Court went out of its way to find that this evidence was improper and to give Lovell a new sentencing hearing. And I think it's really interesting just how far the Supreme Court went out of its way. I think part of what was driving that is this is a capital sentencing proceeding. But they were bothered by this religious evidence. And it was inadequately briefed on appeal, but the Supreme Court points out that notwithstanding the inadequate briefing and the really weak objections that were made during the hearing, and even though a capital sentencing hearing has a very, very broad range of evidence that's relevant, the court said this was, quote, obviously improper, which I think is surprising. But they say it's obviously improper and unfairly prejudicial because in the Supreme Court's view, this inserted a religious test into the proceedings. It invited the jury to shift responsibility for the death sentence off of themselves and onto someone else like the LDS Church's first presidency. So the takeaway from Lovell is just be careful if you have religion come up as an issue in your case. I think you can argue that Lovell should be limited to its unique context, the capital sentencing proceeding. And if you need an example of a case where religious evidence was admissible, you can look to State versus Vallejo. In that case, the defendant was the one who actually introduced the evidence and the state was just responding to the evidence that he admitted. And I think that was part of the problem in Lovell, is the Supreme Court found that while Lovell had called his former religious leaders, they didn't really get into any doctrine or the fact that he'd been excommunicated. They were just there testifying about how remorseful he was and that he was a changed person. In contrast, in Vallejo, he was a LDS bishop that was accused of sexual abuse while he was serving as bishop. And he introduced evidence about the fact that he was serving as bishop and all the time that he put in to serving his congregants and how much he loved the calling and the opportunity to serve, and the state then put on evidence to rebut some of that information. But just tread lightly when you're dealing with religious evidence.
Chris, you had to show that South Park clip just as I was taking a sip of my second cup of coffee this morning. All right, let's talk about another U.S. Supreme Court case, U.S. versus Rahimi, dealing with the Second Amendment.
I don't think the guns are a good idea.
Marge, we're responsible adults. And if a group of responsible adults can't handle firearms in a responsible way...
Sorry. Uh-oh. Me again.
Sorry.
Don't love Homer's trigger discipline there either. All right, so Rahimi is a case about an extremely irresponsible gun owner. So Rahimi got into an argument with his girlfriend and physically dragged her to his car. The girlfriend escaped and was running away, but Rahimi retrieved a gun and started shooting. And it's kind of unclear from the record whether he was intending to shoot the girlfriend or a bystander who was watching this all unfold. Either way, it's kind of like a Red Dead Redemption sort of situation. So he's shooting towards multiple people. And so the girlfriend got a restraining order that prohibited him from possessing guns. He later violated that restraining order by approaching her home in the middle of the night and contacting her on social media. He also threatened a different woman with a gun, and police identified him as a suspect in at least 5 additional shootings. So a really, really good example of an irresponsible gun owner here. Police eventually searched his home pursuant to a warrant and found a pistol, rifle, ammunition, and a copy of the restraining order that forbade him from having firearms. And this is not actually contained in the opinion, but I went to a CLE and saw a talk by the attorney at the DOJ who argued this case in the US Supreme Court. And according to him, at least, the restraining order forbidding him from having firearms was in the same closet where he kept his guns. Like, it was like the guns, the ammo, and the restraining order saying you can't have these things. Federal statute here forbids firearms possession by people subject to domestic violence restraining orders under certain conditions. It requires notice, requires an order preventing stalking, harassment, and it requires a finding that the defendant represents a credible threat of physical safety, or the order must expressly prohibit force or violence. But that's the critical, that first part is the critical language there, represents a credible threat to physical safety. Rahimi moves to dismiss, saying that this order violated his Second Amendment right to bear arms. The district court denied his motion to dismiss, but the Fifth Circuit reversed and held that the restraining Rahimi from possessing firearms violated his Second Amendment rights. The Fifth Circuit, by the way, is the new Ninth Circuit in terms of doing stuff that the U.S. Supreme Court doesn't like. Goes up to the U.S. Supreme Court, and in an opinion by Chief Justice Roberts, the court holds there's no constitutional violation here under the Second Amendment. When a restraining order contains a finding that an individual poses a credible threat to physical safety of an intimate partner, that individual may be banned from possessing firearms while the order is in effect. Since the founding, our nation's firearms laws have included provisions preventing individuals who misuse firearms from possessing firearms, and the federal statute here fits comfortably within this tradition. So getting into sort of the jurisprudence behind this, because this is important because we're seeing these types of claims in Utah too. So the scope of the Second Amendment is determined by the history and tradition of firearms regulation. And according to the Supreme Court, some lower courts have misunderstood this to mean that the law was trapped in amber. So in other words, if you didn't have an exactly identical anti-stalking law, for instance, in force in 1798, or 1789, then that means you can't have one now. And the U.S. Supreme Court rejects that overly rigid approach. They say, well, the Second Amendment protects modern guns, right? It protects modern arms and not just muskets and sabers. And so modern firearms regulations similarly don't have to have historical twins. They merely need to be analogous enough to pass constitutional muster. So they point to a couple of historical laws, surety laws and common law affray. This is where the opinion gets really, really fun for like appellate nerds like me. Like if you want to read old-timey pleas of the crown where all the S's look like F's for some reason. You know, so you have this wonderful history about Anglo-Saxon Frank pledges where like you and your bros would get together and all swear that if one of you acted up, the others would all drag him into court and make him answer. This later evolves into a system at common law where if there's probable ground to suspect that somebody's going to misbehave, you can force them to post bond and forfeit that bond if they break the peace. Husbands and wives apparently used this bond posting system to prevent domestic violence, and it's also, there's at least some history of it being used to prevent firearms abuse. There's also this concept of affray, which going back 1,000 years prohibited public fighting and riding or going around armed with dangerous or unusual weapons in disruption of the public order, and this could be punished by imprisonment and forfeiture of the weapons in question. So taken together, all of these common law precedents the Supreme Court holds suggest what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. I want to highlight, though, the limits of this holding here. Clear threat of physical violence to another. The government suggested a different test. The government suggested a test as to whether someone is a responsible firearms owner, and the U.S. Supreme Court rejects that. They say that's too vague, that's not enough. Merely asking whether somebody's a responsible firearms owner is not enough. They have to have pose a clear threat of physical violence to another. If they do, then we can preemptively disarm them even without an existing criminal conviction. So the takeaway here is, we've been seeing quite a few Second Amendment challenges in Utah in the district courts, complaining that Utah law violates the Second Amendment because it doesn't exactly mirror founding era law. And the hope is that Rahimi should answer some of these criticisms. It makes clear that firearms regulations need to have a historical analog to be constitutionally permissible, but they don't need to have a historical twin. And so if there's a reasonable relationship between the presentation of a risk of physical danger and the need to disarm somebody, then the U.S. Supreme Court is more likely to uphold it.
Whoops. This is a case about a defendant who really wanted the plea agreement. He wanted specific performance, and he didn't get it. So the background is the state offered Molina a plea deal that on the Friday before his Monday justification hearing, and that justification hearing had already been continued twice. And if I'm remembering right, I think there have been a lot of delays due to COVID and other issues with this trial. So there's been a lot of continuances, and he finally gets a plea deal Friday before the justification hearing is scheduled, and he likes it. And he likes it especially because the trial court agreed to bind itself to the state's recommendation, sentencing recommendation, under the rule. And so he says, yeah, I'll take that deal. Let's get it entered. But the prosecutor finds out, oh, I didn't actually have authority to make that sentencing recommendation. And so prosecutor calls defense counsel back Friday night and says, sorry, I'm rescinding the offer, but if Molina wants to go ahead and plead that part of the deal, he can accept that part of the deal, but I can't make the sentencing recommendation that the court has bound itself to. And Molina doesn't like that. And so fast forward to Monday morning, they're there for the scheduled justification hearing, and Molina tells the court, hey, that plea agreement we talked about and that you agreed to bind yourself to, I want specific performance because I have detrimentally relied on that plea agreement. And here are his reasons for his detrimental reliance, his justification. He says, look, I called off all the witnesses that were going to testify today. And I also told the judge that I was willing to accept this plea deal, and part of it was that he'd serve another year in jail. I told the judge that I was willing to do that, and so now the judge knows that. And I've also diluted my right to a speedy trial because now I can't go forward with the justification hearing today, and it's going to be really hard for me to get these witnesses back on board. And the trial court bought it and said, yeah, specific performance, prosecution, you've got to honor that plea agreement. But this was a state's appeal where we got the district court reversed. And the Court of Appeals finds there's actually no detrimental reliance here. Detrimental reliance is doing things like providing information to the government, actually testifying for the government, you confess your guilt, you return stolen property, you actually make restitution, you submit to a polygraph, or you waive certain procedural guarantees. There wasn't anything like that in this case. The plea agreement itself didn't require Molina to call off his witnesses. That was something that he did voluntarily based on his expectation that the trial court was going to accept the plea agreement. But there was no certainty that the trial court was going to accept the plea agreement. Even though it had already bound itself to the sentencing recommendation, the trial court still had to find that the plea was knowingly and voluntarily entered before it could accept the plea. And just telling the trial court that you're willing to accept a plea is not detrimental reliance, because defendants always do that during the plea hearing, the plea colloquy. But again, a trial court isn't bound to accept the plea. The trial court still has to find that it's knowing and voluntarily entered. And defendant's willingness to plead guilty, the court points out, that wouldn't be admissible at a subsequent trial or a justification hearing, anything like that, if the trial court decided that it was not going to accept the plea. And finally, just mere speculation that it's going to be really hard to get those witnesses to appear at a continued hearing is not enough. Again, just generally throwing that out there, even where you've already had 2 continuances, isn't enough. You've got to specifically identify the witness. You've got to demonstrate that they're unavailable. You've got to explain why you have no other source for the testimony that that witness would provide. And you've got to show why the lack of that testimony is prejudicing you, or why it will prejudice you, before you can actually establish, or you can rely on that for detrimental reliance.
A quick follow-up, not really question, but comment by email that I would really like to pass along, actually. So we were talking about State versus Jolly and the importance of vindicating victims' rights. I received a message from Professor Paul Cassell at the University of Utah Law School, who also works extensively with the Utah Crime Victims Legal Clinic. And so this is worth pointing out. I said the Utah courts have been really willing to entertain interlocutory appeals to protect the rights of victims. This is in very significant part due to the advocacy of Paul Cassell and his colleagues like Heidi Nistel at the Crime Victims Legal Clinic. They were counsel in Jolly, they were counsel in FL, and so he had specifically reached out to make sure I forwarded along to you that if you identify an important issue that implicates the rights of victims, don't just check in with the AG's office, check in with them as well, right? Because the victims have an independent interest and the Crime Victims Legal Clinic is willing to help represent them. So feel free to reach out to them directly, or if you see an issue that implicates victims, if you reach out to me, I can also forward it along to them as well. So thank you, and thank you, Professor Cassell, for watching in. I also received a picture that I wish I could share from everybody, but regarding Rahimi, a picture of Danny DeVito with 2 guns that said, so then I just started blasting. But imagine that in your Danny DeVito voice. Okay, so let's talk about closing arguments. I have 2 cases here. First one is State versus Harris. So during the closing argument, the prosecutor stated, at the start of this trial, the defendant had the presumption of innocence. But now that presumption's gone. The evidence you heard this week, the evidence shows beyond any reasonable doubt that the defendant is guilty of each of the crimes charged. And so the question that court's presented with here is, was this proper? Was it proper for the prosecutor to say the presumption of innocence is gone? And the answer is, we still don't know. We still don't know for sure. The court says, well, many states hold that these arguments are proper. Many states hold that these arguments are improper. And the issues raised in ineffective assistance of counsel here, it's not preserved. And given that there's sort of a disagreement about how to deal with this, you can't show ineffective assistance of counsel. So that's the narrow holding, but I want to give you a broader takeaway here, which is that the safer approach is to avoid arguing during closing that the presumption of innocence is gone or that it no longer exists. I think there's a reasonable argument to be made that when a prosecutor says that, they don't mean it literally. They mean it figuratively. They mean to say that the overwhelming evidence here has overcome the presumption of innocence. But if you do read it literally, it is technically legally false. As a legal matter, the presumption of innocence does apply until the conviction. It does not apply just until the end of the presentation of evidence. And the Court of Appeals, in this opinion, even though it doesn't stake a position on one side or another, it seems really, really uncomfortable with these sorts of arguments. And so there's just no need to risk it. Argue based on the strength of the evidence, avoid arguments saying things like the presumption of innocence is gone or that the presumption of innocence no longer exists. You want to argue instead that the state has easily overcome the presumption of innocence. Second closing argument case here, State versus Dew. So this is a case in which Dew is charged with 13 counts of sexual exploitation of a minor. During closing argument, the prosecutor said the case was important because the charged images were not just images, they were kids who can't speak, who can't call for help, and whose images were being traded like baseball cards. So the state argued on appeal that this is permissible because the prosecutor's arguing that this is not a victimless crime, that possession of child sexual abuse material has real victims. The Court of Appeals rejects that argument. Court of Appeals says that these arguments are improper because they called on jurors to issue a verdict based on a desire to protect and vindicate the voiceless and victimized children instead of one based on fair and impartial review of the evidence as to whether Doe actually committed these crimes. So even though, and this is true, by the way, they hold that this is improper, even though the prosecutor later says, I'm not asking you to convict based on the children's inability to speak for themselves, but instead asking you to convict based on the evidence. The court finds that, no, you're asking, by saying, these children can't speak for themselves, you need to speak for them, that's an improper argument. So we want to confine our arguments to the evidence before us and saying you should convict because the evidence here is strong, not because we need to speak for somebody or because we need to take revenge on behalf of somebody.
This is kind of what happened in Goodall. In two cases about Miranda here. One, Goodall is a case where Miranda was not violated, and there was an actual polygraph test that was part of the interrogation. And then a second case where Miranda was violated. But in Goodall, so defendant sexually assaults his girlfriend. He agrees to speak with the police. He's Mirandized, and he signs a waiver form. And then tells the officer, who I think it was the chief of police, that the sex was consensual. And the chief says, okay, well, how do you feel about taking a polygraph? And Goodall says, yeah, I'll do a polygraph. And he does a polygraph, but before he does the polygraph, he's Mirandized again, and he signs another waiver. And he does the polygraph test, and the chief says, sorry, buddy, you failed. And apparently 5 minutes later, that was enough to get him to admit to making a bad decision. And he bursts into tears and admits that he'd messed up. And the trial court denied the motion to suppress. There's a motion to suppress claiming that the Miranda waiver was involuntary. Trial court denies that, and the Court of Appeals affirms, finding that the waiver was voluntary. The issue was his will overborne? And that wasn't the case where he had 2 Miranda waivers in short succession. This wasn't his first arrest. He was familiar with the justice system. He was well rested. He was in good health. The interviews themselves were just over 2 hours total. And there were no coercive police tactics or improper threats. The chief didn't administer the test like the officers in our clip did. And the court specifically finds that the use of the polygraph test results was not coercive because there was no statement that those could be used at trial. Let's see. I show the countdown clock as we've got just some seconds left. Should we? Okay. We'll break again for 10 minutes, and then we'll come back and talk about the other Miranda case. We're going to talk about the second Miranda case. This is State versus Schaefer, where we didn't come out so well, and the court found that there was a Miranda violation. And I think the thing that undid us in this case is exactly what you see in the picture here, which is the handcuffs to the waist belt. So in Schaefer, the police get a warrant to get a DNA sample from Schaefer because he matched the description of a suspect that was seen near an apartment building where a 4-year-old girl was sexually assaulted. And the officer's car didn't have a safety cage. So he handcuffed Schaefer in front and put on a waist belt and attached the handcuffs to the waist belt so that he could drive him to the station. And then while still handcuffed, he escorted Schaefer into a small interview room at the station. Then 2 armed officers came in. They took his blood, his saliva, they took photos of him, and then they closed the door. They did uncuff Schaefer while they were processing him, but the cuffs were still attached and hanging off of that waist belt. He was always wearing the waist belt. And once they're done taking the samples, then an armed detective enters and says, hey, thanks for letting us take your samples. You got any questions? And Schaefer says, yeah, in fact, I got some questions. And so the detective says, okay, well, I'm going to read you your Miranda rights. He reads him Miranda. And Schaefer's response is, yeah, I think I will need a lawyer, because apparently you guys got me on a search warrant and stuff, and it seems really serious. From what I've read, I'm going to be needing, and that's when the detective jumps in, cuts him off, and continues the interview and says, well, do you have any questions? And Schaefer says, well, can I go home? And the detective says, well, I'll take you home if you don't want me to ask you any questions. And they continue to talk about the investigation, and eventually the detective gets the admission that Schaefer had in fact been in the area of that apartment complex. And once he gets that admission, I guess the rest of the discussion didn't really go anywhere, and so he handcuffs Schaefer again, drives him home. Motion to suppress based on violation of his right to counsel during the custodial interrogation. He claims it was custodial. The trial court denied the motion because it concluded that Miranda warnings were not necessary because Schaefer wasn't in custody. The trial court said there was no coercive or manipulative statements. The whole thing was just about an hour. He understood that he could go home after the DNA sample was taken, and he was taken home. Once the sample was taken, the interview after that was just 10 minutes. Court of Appeals reverses, finds that Schaefer was in custody and that the detective failed to honor his request for counsel. So custody is a two-step inquiry. Would an individual feel free to leave? But that's not the end of the inquiry. If the individual would not feel free to leave, then you ask, did the environment present the same type of inherently coercive pressures as the type of station house questioning that was present in Miranda? Court of Appeals finds that Schaefer was in custody. He was handcuffed, and even when he wasn't, he was always wearing that waist belt, and the cuffs were attached to that waist belt. Court of Appeals emphasizes the presence of armed officers, that the door to the interview room was closed. He was told he was a suspect, and during the interrogation period, he wasn't advised that he could go home. And then finally, Court of Appeals finds that the questioning in the closed room had the same badges of coercion that existed in Miranda. And even though he said, I think I will need a lawyer, that is an unequivocal invocation of the right to counsel. And the Court of Appeals cited a bunch of cases where defendants had made similar statements and found that that was an unequivocal invocation of the right.
And just a quick follow-up on that. There is the state has filed a cert petition in the Utah Supreme Court in Schaefer. That's currently pending as of the last time I checked. This would be, I think, Monday or Tuesday, so we haven't gotten a decision on that, but a cert petition in that case is pending. Next one, talk about the juvenile transfer statute, in re EM. So EM is a 15-year-old who killed one person and wounded several others in a racially motivated drive-by shooting. And if you look at the facts of the case, it's actually really, really lucky that he only killed one person. The juvenile court transferred his case to the district court, and EM appealed. So the issues are, how do you apply the juvenile transfer statute, and what factors may be considered in determining whether transfer from a juvenile court to a district court to be tried as an adult is appropriate. So a little bit of statutory background. The juvenile transfer statute is in this section of the Utah Code, and it states that a 15-year-old's case may be transferred to district court only for attempted or completed murder or attempted or completed aggravated murder. This is a result of some statutory changes that made it harder to try juveniles in district court. The court must also find, the juvenile court, in order to transfer it to district court, must also find that it is contrary to the best interests of the minor and the public for the juvenile court to retain jurisdiction over it as a juvenile matter. And then it provides a list of factors that the court should assess in weighing whether it's in the interest of the public or in the interest of the minor. So seriousness of the offense, protecting the community, the minor's history, whether the offense was violent, criminal record, likelihood of rehabilitation, and so on. So two holdings to look at here in Ray EM. First is about how to approach this statute in general. The Utah Supreme Court holds that this statute requires a holistic analysis that can't be reduced to a formulaic calculation and vests broad discretion with juvenile courts in deciding whether to transfer a case to district court or not. So this means that courts consider all sorts of factors. Juvenile courts can consider all sorts of factors, including ones not specifically listed in the statute. So this is a very broad sort of totality of the circumstances analysis. EM argued that the limitation of transfer to murder crimes must show that the legislature wanted the statute to be construed narrowly and to be limited only to the factors that are expressly limited in the statute. But the Utah Supreme Court rejects that as contrary to the plain text. So if you have a case involving juvenile transfer, this is a broad, holistic analysis that should incorporate every factor. And the Utah Supreme Court is signaling here that if it gets one of these cases on appeal, it's going to evaluate it with a hefty degree of deference to the discretion of the juvenile court. Second sort of minor holding here that is maybe more important to us on appeal than it is to you, but that trauma can sometimes be an aggravating factor and not just be a mitigating factor. So EM presented evidence of a very traumatic childhood that he had as growing up in South Sudan and then later coming to the United States as a refugee. And the juvenile court, in weighing this for transfer, looked at this and said, well, look, the degree of trauma you have is so great that I'm actually worried that you're going to need services for longer than the juvenile court can provide them to you. And so I'm going to factor that into my decision of treating you like an adult, because I don't think that a juvenile court can retain jurisdiction over you long enough to give you the sort of help you need to recover from this trauma. So EM argues on appeal that that's not fair to use this past trauma against him, but the Utah Supreme Court rejects that claim. And this is sort of one of those classic law school discussions about the purposes of criminal law in the first place, right? You might argue that being subjected to trauma makes you less morally blameworthy, but it may arguably also make you more dangerous to other people and increase the need for incapacitation. Utah Supreme Court, again, consistent with its approach of deferring to the discretion of juvenile courts here, says a juvenile court could view this as a factor weighing in favor of transfer and not just weighing against transfer.
Okay, State versus Zimpher. We're going to talk about ultimate issue testimony under Rule 704. Zimpher gave his girlfriend a pill to help her sleep. At least that's what he told her it would do. And then while she's asleep, he takes her phone and takes a video of her exposing her breast and touching her nipple. And then while he's still recording, he exposes his penis, puts it on her face, and then while he's recording, you hear her mumble something like, "What are you doing?" and saying, "I've got to sleep." And but that's all in the video that he used her phone to take. So at trial, the detective who investigated this is asked, when you reviewed the video, what did you find? What did you see? And he says, well, in reviewing it, it didn't appear that the girlfriend was awake and that she gave consent. And then defense counsel said, well, did the mumbled dialogue at the end of the video, did that change your mind? You know, she's mumbling some things. And he says, no, I didn't change my mind. Looked to me like she was not awake and that she wasn't consenting. So Zimpher claimed that this was improper ultimate issue testimony. But the Court of Appeals disagreed with that. The testimony was admissible. Rule 704A allows opinion testimony to embrace an ultimate issue, but opinions can't tell the jury what result to reach, or they can't give legal conclusions. But the court recognizes there's no real bright line between these two circumstances. But they do give some characteristics of improper legal opinions or improper ultimate issue testimony. And that testimony, it looks like testimony that is framed in a way that's not helpful to the fact finder, that's saying, yes, she did not consent as a matter of law, or creates a danger that the jury might look to the witness's legal conclusion rather than to the judge for guidance. Or again, tying the testimony to the requirements of Utah law. Those are hallmarks of improper legal opinion. The testimony here from the detective, the court says, was not an improper legal opinion or opinion on the ultimate issue, because the detective was just responding to questions about how the investigation began. What did you do, and why did you do what you did? And he said, I watched the video. This is what I believed it showed, and that's why I followed up on it. It was just an initial step in the investigation. He wasn't saying, yes, in fact, I believe the girlfriend was asleep and did not consent. That doesn't properly characterize his testimony. And same with the testimony about the mumbled exchange at the end of the video about that not changing his opinion. That wasn't an improper ultimate opinion. And his testimony wasn't tied to any legal requirement for consent. When he used consent, it was clear that he wasn't using that in the legal sense. He was just saying, in my view, she wasn't agreeing to what he was doing. So witnesses can use legal terms, they just can't use them in a legal sense. Zimfer also talks about prior consistent statements under Rule 801 D1B. Zimfer, as part of his defense, he'd alleged that the victim was lying about being asleep during the video, and the reason that she was lying is because she had accused him of stealing her anxiety medication. And so in response to that, the state admitted some of his journal entries, or some of the victim's journal entries about her relationship with Zimfer to counter that allegation. So he argued on appeal that the journal entries did not predate additional motives to fabricate that he had alluded to in his opening statement. Additional motives to fabricate beyond the motive that he actually argued at trial, which was, well, she stole my medication, and that's why she's trying to get back at me now. But because he hadn't argued that as a basis for excluding the prior consistent statements, he couldn't use that on appeal to exclude those statements. So prior consistent statements do have to predate a motive to fabricate, but they only have to predate the motive to fabricate that the defendant is alleging. He can't come back and say, well, I know I alleged this one, but there's also 2 or 3 others. You don't get to do that, just one.
Quick question.
Or at least the ones that you argue.
Quick question here, Chris, about Zimfer. Question is, didn't defense questioning elicit the detective's response? Is that a factor?
I think so, yeah. I think that is a factor, but either way, I think a witness, they still can't give that ultimate opinion testimony, and to the extent that they do, then I think there might be an ineffective assistance of counsel claim there, but yeah, I think that is a factor.
Okay, and another U.S. Supreme Court case. City of Grants Pass versus Johnson. This case is interesting both for its actual holding and also just for the broader signals that it sends about the way our current composition of the US Supreme Court views the Eighth Amendment. And so we'll walk through kind of both of those. So this all starts with the Ninth Circuit case, Martin versus Boise, which made quite a few headlines, in which the Ninth Circuit enjoined enforcement of a law that criminalized public camping. And the Ninth Circuit said that's cruel and unusual as applied to involuntarily homeless people whenever there's a greater number of homeless individuals in a jurisdiction than the number of beds available in shelters. So the idea is that you can't hold somebody criminally responsible for being out and being homeless if they have no other place to go, if they don't have a shelter bed that's already available for them. Also, the court holds beds with a religious atmosphere don't count towards this number because the government can't require people to participate in religion. And you can sort of see the sort of intuitive moral logic behind where this is coming from. As Sotomayor puts it in her later dissent in Grants Pass, people shouldn't be forced to choose between staying awake and being arrested, right? So the idea is you can't go out and arrest people or punish people criminally for homelessness-related issues unless you can show that there's a shelter bed for every single one of them, right? So in the ensuing years, cities in the Ninth Circuit found that this made it increasingly difficult to deal with the homelessness problem. This case is really remarkable for the number of amicus briefs that are filed on behalf of cities and municipalities here. The city of San Francisco, for instance, files an amicus brief that says over half of its offers for shelter and services are rejected by unhoused individuals who often cite the Ninth Circuit's Martin decision against the city as their justification to continue occupying and blocking public sidewalks, basically saying, you can't make me move because the Ninth Circuit said that you can't make me move. Other cities similarly report that Martin may have actually made their homelessness problems worse and may have made it more difficult to get persons experiencing homelessness into support services. So the facts of this particular case, Grants Pass has various laws against sleeping or camping in public. Initial violations of the laws result in a fine, and subsequent violations in criminal trespass, although it's kind of not clear whether the actual criminal law is ever used here. 2 homeless persons file a class action challenging those laws under the Eighth Amendment in Martin. And the district court enjoins enforcement of the laws under Martin, finding that the available beds that were available for homeless persons in Grants Pass were there for transitional housing and not for emergency shelter. And they also required abstaining from smoking and attending religious services, so those don't count towards the count. A divided Ninth Circuit panel affirms, and the city of Grants Pass seeks cert supported by hundreds of cities and states, including Utah. Utah signed on to an amicus brief on this. And this is really kind of an unusual case in that, the sort of left-right political divides that you might expect don't necessarily break down the way you might expect, at least when it comes to governments, right? As I pointed out before, even the city of San Francisco is saying this Ninth Circuit decision is too onerous for us. Okay, so that goes up to the US Supreme Court. US Supreme Court, in a majority opinion by Justice Gorsuch, says that Grants Pass restrictions on camping do not violate the Eighth Amendment. And the way the court gets there is significant. Like I said, that this is important to think about not just the application in the particular case, but how the US Supreme Court is going to be thinking about Eighth Amendment cases going forward. So the court says, well, look, as originally intended, the Eighth Amendment was intended to forbid ancient and brutal punishments that were technically still legal at common law and at English law at the time of the founding, such as like disemboweling, drawing and quartering, burning alive. And thus, the court says the original focus was on the method or kind of punishment, not whether the government may criminalize a particular behavior in the first place. So like this is the sort of thing that the court is worried about. This, by the way, this is Meister Franz Schmidt, the executioner of Nuremberg. There's a great history. He wrote a diary, like the actual executioner did, that there's a great history written about it called The Faithful Executioner. I should add, by the way, that the last time I mentioned that, at the SCOTUS review, one of the reviews was, wow, you do really different things on your weekends than I do. This is what appellate attorneys like to read on the weekends. It's like histories of 16th century executioners. Anyhow, all right, so the court, the U.S. Supreme Court says that the original focus of the Eighth Amendment is on the method or kind of punishment, not on what can be criminalized and what can't be. However, U.S. Supreme Court case Robinson versus California, the court held in the 1960s that it's cruel and unusual to criminalize the mere status of being addicted to narcotics. So you can't make it a crime just to be a drug addict. The majority opinion in Grants Pass strongly hints that it thinks Robinson was wrongly decided, and that if Robinson had a claim at all, it was in due process and not under the Eighth Amendment. But the issue's not raised here. Nobody's asking the court to overrule Robinson, so the court just sort of throws some shade on Robinson and then keeps going on. What they say here, though, is Robinson's distinguishable. Unlike Robinson, Grants Pass does not criminalize status, it criminalizes actions. It criminalizes the action of camping in public. And so Robinson is just limited to status crimes, and it cites Powell versus Texas, which is a later Supreme Court decision saying, yeah, you can't criminalize, say, being an alcoholic, but you can criminalize being publicly intoxicated. And the court says it sees no reason to extend Robinson any further. Other doctrines already address the issues that you might be worried about here, like necessity, insanity, diminished capacity, duress. Court also points out that it thinks the Ninth Circuit's decision in Martin is really hard to apply in the real world. Like, how do you determine whether a person is involuntarily homeless on the spot? How do you know how many people are homeless on any given day and whether it exceeds your shelter capacity? Like, it's a really sort of elegant calculation in theory to say, well, you shouldn't be able to jail somebody unless you can show that there are more shelter beds than there are homeless people. But in order to apply that in practice, you would need to have a running count of both of those numbers at all times. There's a question about when a particular bed is adequate. Is it okay if the shelter bans smoking? Does it have to be indoors? Does it have to provide medical care or security? What other functions are protected other than sleep? There's a big concern, and this comes up at oral argument, that this is going to accidentally legalize, that this line of decisions is actually accidentally going to legalize public urination. And then, multiple cities have cited that Martin has resulted in reduced use of existing homeless services. Policymakers need to prioritize these different needs, and the constitutional structure allows for local experimentation in how to deal with the problem of homelessness. So, takeaways from Grants Pass. As I alluded to before, I think there are two. The first is the immediate takeaway, which is that this removes uncertainty about the legality of public camping bans. Even for jurisdictions outside the Ninth Circuit, a number of jurisdictions had been finding some judicial pushback based on taking that Ninth Circuit precedent as persuasive authority. This removes that uncertainty, and it makes clear that criminal bans on public camping don't violate the Eighth Amendment. The other long-term takeaway is that this decision signals there may be big changes coming to the Supreme Court's Eighth Amendment jurisprudence in the coming years. Robinson and the idea that you can't criminalize status crimes is always an outlier, but Grants Pass really seems to take issue with a lot of broader Eighth Amendment precedent. If you read Justice Gorsuch's opinion, you would really come away with the conclusion that he really thinks that the only thing the Eighth Amendment applies to is like actual torturous executions. And so future cases might be asking SCOTUS to re-examine some of these recent evolving standards of decency case law, and I wouldn't be surprised if in the next 5 or 10 years we might see a really big shift in the way that the U.S. Supreme Court views Eighth Amendment issues.
Okay, just a quick note about discovery under Rule 16 and State versus Wilden. If you don't know about it already, you should. The state asked the court to order Wilden to provide audio recordings of his counsel's interviews with witnesses under Rule 16b. But Wilden said, no, that's work product, and it's protected by Rule 16b-4. And the trial court disagreed and said, that's not work product. as long as it's redacted, to take out any of counsel's opinions, analysis, or strategy. If it's just what a witness told a defense investigator, that's not work product. This went up on interlocutory appeal, and the Utah Supreme Court reversed and said attorney interviews, defense counsel interviews with witnesses are work product, and they don't have to be disclosed under Rule 16. So we have to give them our interviews. They don't have to give us their interviews. Work product, the court explains, is things like documents or tangible things that are otherwise discoverable. They're documents that are prepared in anticipation of trial by or for another party or that party's representative. That discussion or that definition comes from Gold Standard versus American Barrick. But it's interesting, the court recognizes that this definition doesn't quite work because you prepare things, you have defense counsel preparing things in anticipation of litigation, like notices of alibi, things that are required under the rules. And so the court puts a little gloss on this definition and says, work product really relates to assembling information, sifting it, preparing legal theories, planning strategy, being able to do all of those things that lawyers do without any interference or without having to disclose it to the other side. So work product, even though you could say that definition fit a notice of alibi, work product doesn't apply to documents that are prepared with knowledge that they will be viewed by opposing parties. Then the court notes that this would mean that drafts of documents that you produce, that you eventually file the final draft, but the previous drafts, those would be work product. So the court rejects the state's argument that verbatim witness statements are not work product. This might have worked under the old version of the rule, but the rule was rewritten in 2021, and the new rule, the new version of the rule, unlike the old one, doesn't recognize a distinction between core attorney work product, which is like that stuff we were talking about, counsel's thoughts, impressions, strategy. The old rule made a distinction between that kind of what it called core work product, or what the law has characterized as core work product, and factual work product, like an interview with a witness. Now, the good news is that Justices Hagan and Peterson concurred, and they pointed out that there's lots of other jurisdictions that have solved this problem. The federal rule and the rule in 29 states allow for reciprocal discovery. And so they've invited a proposal to fix Utah's Rule 16. And I'm not sure the status of that, but hopefully, are you aware, David? Anybody aware of whether that's been proposed? Hopefully it has. And we can get this fixed so that we can then get the type of discovery that the prosecution was seeking here in Wilden.
Okay, let's talk about lay opinion testimony and rolling your SUV. So, in re ADC, this is a case involving ADC, who's a minor. He borrows his dad's Cadillac Escalade, and he tries to make a 90-degree turn at 45 miles an hour. Anyone want to guess what the result is of trying to make a 90-degree turn at 45 miles an hour? Yes, I assume you already know. Yeah, he rolled the car and crashed it through a fence into somebody's backyard. So there's a variety of testimony from police officers offered at the trial, and a lot of it couched in the form of opinions. So the car exceeded the speed limit, the car rolled, hit the curb, then flipped itself back upright. Descriptions of the velocity required to roll and crash the trees, crash through the fence and trees, right? So the idea, like an officer saying, yeah, it would have taken a lot of speed to be able to roll in this way. Opinion that it's harder to control a fast-moving vehicle than a slow-moving vehicle. And then an opinion that there were skid marks on the road that are yaw marks, which indicate that the car was sliding sideways at an excessive speed. So the The claim on appeal is that all of these things are improper because you would need an expert to testify about all of these things, and the police officers merely offered this as lay testimony. And the Court of Appeals holds all but one of these statements as admissible as lay opinions because they're within the ken of the average bystander. So if you look at these things again, like it doesn't take, you know, an expert in physics and accident reconstruction to know that you'd have to be driving pretty fast to be able to roll a large SUV over and crash through a bunch of trees and through a backyard fence. It doesn't take an expert to know that it's harder to control a fast-moving car than a slow-moving car. The one concern that the Court of Appeals has is this last one here, the idea that skid marks are yaw marks indicating sliding sideways at excessive speed. On that point, the court says, we're not going to express an opinion about whether that's permissible lay testimony because we find no prejudice, but they do sort of express some skepticism about whether that's a permissible lay opinion or something that you'd need an expert about. And that concern seems plausible to me, right? You would worry about whether referring to skid marks as yaw marks is within the sort of average common ken of the average bystander. So my takeaway from this is use your common sense. If the conclusion sounds like you need an expert for it, you probably do. And if the conclusion sounds like you don't need an expert for it, you probably don't. The one other thing that I would add that the court picks up on as well in a footnote is that the state should be really careful about having it both ways, right? So if you're offering somebody as a lay witness, you're offering them their opinion to the extent that it's within the sort of common knowledge of the average bystander, right? And it's hard to argue that what somebody's testifying about is within the common knowledge of an average bystander if you're prefacing their testimony by talking about how much training and experience they have, right? So officer, what sort of training and experience have you had in traffic scene reconstruction? In your extensive training and experience, what was your opinion as to this, right? The more you're relying on training and experience, the more it sounds like you're really asking for an expert opinion and not a lay opinion. And so the court sort of suggests in a footnote that district courts may be able to limit that sort of testimony under Rule 403. There's sort of a tension and you want to explain the basis for their opinion, but the more it sounds like you're relying on expertise, the more likely it is to be an expert opinion and not a lay opinion. We just add as well that our current Court of Appeals in particular is really, really sensitive to the idea of prosecutors talking about out of both sides of their mouth, right? So the court just really doesn't like the looks of the idea of someone saying, well, this is a lay opinion, even though I asked 5 questions about how much training experience they have, right? Even if we might be able to get that through, that makes our Court of Appeals really uncomfortable. And I think kind of justifiably so we want to be careful about policing those lines.
Okay, a quick note about joint representation. In O'Reilly, police stop a car whose passenger compartment has lots of drugs in it. Marijuana, meth, lots of paraphernalia. The driver says, it's all mine. O'Reilly, who's the passenger, she says, well, the pipe and the grinder are mine. They both get arrested, and it turns out the car doesn't belong to either of them, so I guess this is a variation of the not my pants defense. This is, not my, the drug car isn't mine. They're both represented by the same attorney at trial. And the defense, they assert, is everything belonged to the car's owner, which really isn't much of a defense, but that's what they went with. So on appeal, O'Reilly said, look, this joint representation created a conflict of interest because there was a substantial disparity in the evidence where the driver, the co-defendant, had said everything was mine. And she only admitted to 2 items of paraphernalia. And also, O'Reilly also argued on appeal that the trial court was sua sponte required to inquire about the joint representation and whether that was proper. But the holding is on appeal is that there was no conflict of interest because any defense that O'Reilly's attorney could have pursued wouldn't have been materially aided by the co-defendant's admission. The critical issue here was possession, not just ownership, and so the co-defendant saying, well, everything belonged to me, when it's all within everybody's reach, within the passenger compartment, that wasn't much of a defense, and so it wouldn't have helped her. And joint representation doesn't require a sua sponte inquiry from the trial court. As long as the defendant doesn't say anything about it, either of the defendants, the trial court isn't required to ask if the defendant's okay going forward with the same counsel. But if the defendant does complain or make any comment about the joint representation, then make sure that the trial court does inquire, because if the trial court doesn't, if this comes up as an issue, then and the trial court doesn't inquire, then it's going to be an automatic reversal. The appellate court is going to assume that a conflict existed and that the defendant was denied their right to counsel. So just be careful if it comes up.
Okay, next case is about a bar fight.
And I say England's greatest prime minister was Lord Palmerston.
Hit the elder.
Lord Palmerston!
Hit the elder!
Okay, you asked for it, Boggs!
Yeah, that's showing him, Bonnie. Hit the elder.
Lord Palmerston!
What I love about that clip is it's so relatable. We've all been there, right? All right, hands up for Lord Palmerston. Hands up for Pitt the Elder. All right, no hands. Everybody knows it's actually Robert Peel. Okay, good. So, State versus Devon. Devon started a business selling gummies, selling special gummies. Friend bought them thinking they were THC edibles, but in fact they were just CBD gummies. And so Friend, who's hanging out at a bar, texts Devon and says, you sold me some CBD BS, man. I'm going to come over there later and give you these gummies back, and you're going to give me back my money. So Devon goes to the bar. Both of them go outside to talk. There's a back and forth discussion. Devon goes on an angry rant during this discussion, and Friend responds, well, if you're getting that mad at me over $50, I'd say you're hardly a man. Devon then, demonstrates what a cool head he is by assaulting his friend so badly that his friend's jaw has to be wired shut for several months. So, at trial, he claims self-defense, but the jury rejects that theory and convicts him. And on appeal, he raises several complaints about the jury instructions, some of which are preserved and some of which aren't preserved. So I'll hit on sort of two holdings here. Question number one. And show of hands here, and again, I want some participation in this, okay? How many people think you can argue defense of habitation for a bar fight? Yes? No. Thank you, that is correct answer. You cannot argue defense of habitation for a bar fight. So he claimed his counsel was ineffective for not asking for a defense of habitation instruction. The theory was that he could have reasonably believed he was justified in assaulting his friend to prevent a future burglary at a bar, to prevent a future burglary of his home. And the Court of Appeals easily rejects that. You can't argue defense of habitation for a bar fight. Defense of habitation only justifies necessary force, not preemptive strikes at the bar, right? That's the easy one. Second point has to do with self-defense, and has to do with a self-defense instruction that I've seen come up in a couple of cases recently, and y'all have to let me know if you've been seeing it too, which is that the district court abused its discretion by not giving an actual danger instruction. So what this instruction would say is tell the jury that no actual danger is necessary to establish self-defense. The defendant need only reasonably believe that there was actual danger. So, even if I'm not in fact in danger, if the objective circumstances give rise to a reasonable belief that I'm in danger, and I in fact have that belief, that's all that I need. The Court of Appeals holds that the district court did not abuse its discretion by refusing this instruction. So the defendant is generally entitled to have his legal theory of the case placed before the jury if it would not be superfluous to do so because there's not another instruction on point. But courts also have the discretion to refuse an instruction if other instructions adequately cover the issue. Right? So here, the jury's instructed that what mattered is the reasonableness of Devon's belief that it was necessary to use force. And so in the Court of Appeals' opinion, that's enough to adequately convey that no actual danger is required, so there's no abuse of discretion in failing to give it. So if you do get a defendant in a self-defense case who wants a no actual danger instruction, they're not entitled to that instruction as a matter of law. And so you are within your, you're within your rights to oppose that and say it's not necessary. The other instructions already capture this issue. And if the court agrees with you, you're likely to be affirmed on appeal. So the takeaway here, first, that the court can decline an actual danger instruction. The second takeaway is not present on the face of the opinion, but I think it's implicit in it, which is that the courts probably also likely have the discretion to give the instruction if they want to. The no actual danger instruction is a correct statement of the law. What matters is whether what a reasonable person would have believed, and not whether there was in fact a danger. Regardless, that you have the district court probably has discretion to go either way on this. The final point is just to point out the difference between entitlement to an instruction and the sort of whether the argument itself is meritorious. A defendant's not entitled to an actual danger instruction, but they are entitled to argue that to the jury if they want to, right? So regardless of whether the instruction is called for or not, actual danger is not in fact required to prove self-defense.
Okay, we haven't had any Fourth Amendment cases. I know Jeff Gray is bored out of his mind so far. So here's a couple of reasonable suspicion cases.
That's not the only reason he's bored out of his mind.
Yeah, probably not. But anyway, this is about stale reasonable suspicion, State versus Correa. The facts are that an officer is driving. He sees the driver of a pickup truck look at him, look at the officer, and then quickly look away. And so that raises the officer's suspicion. And he starts, he's gathering information about this truck. And he finds out that the truck is registered to a female, but a male, Correa, has been driving it. And about 2 months ago, Correa was cited for not having a license. And unfortunately, the holding here is that 2-month-old information is too stale to establish reasonable suspicion for an investigatory stop. But the court does point out that 2-week-old information is not too stale, and 20-day-old information is not too stale. So I don't know how stale is too stale. Once you get past 20 days, so about 3 weeks. There could be other circumstances that might influence the reasonableness of the suspicion, but Correa holds that at least 2-month-old information is too stale. Okay, I found a Simpsons clip, David.
A family trip with a family bartender. What could be better?
How's it going, Homer?
Oh, lousy. I gotta go to Vermont for some stupid poetry thing.
Homer, don't drink and drive.
Oh, fine. I'll drive between sips.
Yeah, you have to love Homer, don't you?
Whoop! They got an open bar at this thing, right? Wow, troopers from every state in New England.
Including Rhode Island. We're a small state, but we give big tickets.
Okay, State versus Perkins is a great case if you have a citizen informant who notices a drunk driver. The citizen informant in Perkins saw Perkins stagger into a gas station convenience store. He leaves with a case of beer. He puts the case in the back of the pickup truck, but not before taking out one can, opening it, and driving as he drove off. No indication as to whether he was driving between sips. But the citizen informant did not see any driving irregularities, but calls the police and says, "You got a drunk driver." And while en route, the officer finds out that Perkins' license is suspended and he can only drive vehicles with an interlock device. And as you probably guessed, this vehicle did not have an interlock device. The stop and the aftermath, he's got slurred speech, bloodshot, watery eyes, he smells of alcohol, he fails the field sobriety test. He's 3 times the legal limit. That's everything the officer had to justify the reasonable suspicion there. And the court, as you would suspect, finds overwhelming evidence there, and clearly the officer could rely on the citizen informant's report, especially where he had verified much of that information himself.
Right, I had an emailed question. David, you have a lot of Bart Simpson footage. Is there a Simpson family connection? We all have those less educated relatives. And my answer to that will be, when I was in elementary school, kids used to pick on me and call me Bart, and my mother said, "Oh, David, it's just a TV show. It'll be gone in a year or two, and nobody will ever remember it." On that note, okay, so this is a case, State versus Wall, about stakeout questions. You may have seen these, about asking whether you believe somebody is capable of lying. So Wall is charged with aggravated sexual abuse of a child, and the district court forbids the defendant from asking during voir dire, "Do you believe children are capable of lying about significant events?" The defendant appeals and argues that's an abuse of discretion because, oh, well, that's my entire case, is that this child is lying about significant events. Court of Appeals says no abuse of discretion in forbidding the defense from asking this question. So courts should be permissive in allowing voir dire questions and should exercise their discretion in favor of allowing counsel to elicit information, but they're not required to allow counsel to ask every particular question or in any particular way. So courts have, the general rule is courts have very little discretion in asking questions that go towards bias, but much greater discretion in limiting questions that are directed at discovering jurors who would be favorable to your case, right? So the question here about, do you believe children are capable of lying about significant offense, like, that's not a common source of bias. That's just, are you going to be favorable to my theory of the case or not? So some courts call these stakeout questions, basically getting jurors to stake out an opinion on how they would deal with the evidence before the evidence is presented. According to the Court of Appeals, these sorts of stakeout questions about specific defenses, specific scenarios, specific evidence, even if presented as hypotheticals, are improper and should be excluded from juror examination. So if you get this as part of a proposed voir dire question, you can wave Wall around and say, this is improper, you can't ask about specific scenarios, even if you try to mask it as a hypothetical scenario. Asking whether children are capable of lying about significant events was quite clearly aimed at discovering which jurors would be favorable to the defense's theory that the daughter was lying about the abuse, right? This is not really concerned about ferreting out bias. It's a thinly veiled attempt to ferret out which jurors are more likely to believe the defense's case. So the court does note that there could be other ways of asking this question properly. So they analogize, for instance, to that type of questioning you see frequently in cases involving police officers, right? Would you give a police officer more or less weight merely because they're a police officer, or would you treat them like any other witness, right? The court implies that you could ask the same thing about a child. Would you give a child either more or less weight, or would you treat them like any other witness? But it's not the district court's job to suggest that. If a defense counsel asks an improper question, it's not the district court's job to tell them how to ask a proper one. So there's no abuse of discretion here in denying this voir dire question. So, basic takeaway here, the rule is that looking for biased jurors is okay, but looking for favorable jurors is not. And so the closer the individual question is to the facts of the case, the less likely it is to be proper. We do want to enforce this boundary, it's important, but make sure you're thinking carefully about it, right? You don't want to accidentally create reversible error by precluding questions that actually go to bias, but if it's tied to the individual facts of the case, then it's much more likely to be an impermissible stakeout question.
Okay, just a quick note on the Fifth Amendment privilege and who has to claim that privilege. In State versus Salzman, the defendant, he wanted to call his girlfriend as a witness. She was incarcerated in Arizona, and there were some logistical issues. They made her available to testify telephonically, or maybe it was by video conference, but things went longer. She wasn't able to testify, or she wasn't available when the court finally got around to taking her testimony. And her attorney said, oh, and by the way, she's just going to take the Fifth Amendment, she's going to assert her Fifth Amendment privilege anyway. So when they couldn't get her testimony at trial, the defendant asked for a continuance. The trial court denied that motion. And what the court relied on mostly was that, well, the attorney said she's just going to take the Fifth Amendment, plead the Fifth anyway, so I'm going to deny the continuance. But the Court of Appeals says the trial court can't rely on representations from counsel that a witness is going to assert the privilege. The witness has to assert the privilege themselves, but any error was harmless given the speculative nature of her testimony. But just know that the witness has to assert the privilege, not their counsel or someone else on their behalf.
Hey, Chris.
Yeah.
Do you think this extends to spousal privilege?
I don't know.
So the question, by the way, is whether this would extend to spousal
Yeah, sorry,
privilege.
I should repeat that. The question is, does it apply to spousal privilege? I don't know. I think you could argue that it's analogous.
You'd also have the immunity problem, right? Like the testimonial immunity. So it might depend on whether the privilege is running with the immunity.
Right.
Because if there's an immunity there, then you wouldn't want to, you wouldn't be able to call them to testify, right?
Right.
And invoke the privilege.
Okay.
All right, have time for one more Simpsons clip. I don't know if we'll have time for the case law, but at least we can get the Simpsons clip in, which is what I really care about. Okay, so this last case is kind of a follow-up on that distinction between lay and expert testimony. This deals with lay medical testimony. This is a domestic violence case. King beat and strangled his wife. He's charged with aggravated assault, which requires proof of an injury resulting, as charged here, requires proof of an injury resulting in protracted loss or impairment of the function of any bodily member or organ. And so wife testifies at trial that because of her injuries, she's forced to be limited to light-duty work for several months afterwards. And the defense argues, well, that's improper because that's a medical conclusion as to whether she's required to do light-duty work, and so you need a doctor to testify about that. She can't testify that she's limited to light-duty work. Court of Appeals rejects that. They say this is admissible testimony, admissible lay opinion testimony under the rules of evidence in 701. So Rule 701 says if a witness is not testifying as an expert, they can testify in the form of an opinion so long as it's rationally based on their perceptions, helpful to understanding the issues, and it's not based on scientific or technical knowledge, right? And so the idea that you've undergone a beating and then that beating makes you hurt, and then that when you are continuing to hurt and you are impaired in your ability to do your job, you don't need to be a brain surgeon to figure that out, right? So, the wife had been able to perform these heavy-duty assignments before her injuries. She wasn't able to do it after the injuries. There's no apparent intervening cause to explain the change. That causal connection there is apparent from common knowledge, right? You don't need an expert for that. It's a CF here to Shepherd Rock, which is a civil case, which says, look, if you have uninterrupted pain and no intervening cause, you can say that the thing that started the pain is what caused the ongoing pain, right? You don't need to be a doctor for that. Takeaway here again, if the matter really seems like a matter of common sense, you do not need an expert to do it or to testify about it. The one little caveat I would give here is that this only goes to admissibility. It doesn't go to whether the testimony is sufficient to ultimately prove causation. And so the Court of Appeals opinions here says, yeah, this was admissible as lay testimony. We're not going to express an opinion on whether it was enough to convince a reasonable fact finder standing alone, but you get to admit it. So if you want to be extra careful, if you can introduce additional evidence beyond just lay testimony, that's going to clear up that lingering concern that the Court of Appeals leaves open here. And with that, I see we are out of time. You all made it through 278 slides. Good for you, man. We'll hang around for a little bit and chat and take questions if you want. If you have any follow-up questions, feel free to send me an email as well. And Bob, if you have follow-up announcements, go for it.